Good morning, everybody. Happy Thursday. Welcome to the Courtroom Files Live. Get your bingo cards ready. If you don't know what I'm talking about, go to tcfbingo.com and play along with us because we've got Judge Simpson first. So if you've got the adjournment square, you're going to get a fast start.
Christina Costantino appearing on behalf of Mr. Haruska Dennis in case number ending in 1150.
Malika Fatima appearing on behalf of Haruska Dennis on the other cases.
All right.
Mr. Haruska Dennis, could you state your name for the court?
Zachariah Haruska Dennis, Your Honor.
What
Good
are
afternoon, Your Honor. Amy Reiser appearing on behalf of the people.
all right? And what are we doing?
Judges, is the date and time set for PCC. We would be asking to have this matter set for an exam. I believe that discovery is complete.
The same would be for us. We would like to set this matter for preliminary exam.
People have their witnesses available to 12? Yes. Preliminary examination in person will be set August 12th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you, Judge.
Cases of the people versus Anthony Alfaro Callejas.
Good morning, Your Honor. Zach Bonham on behalf of the defendant who's joining us by Zoom.
Good morning.
Sir, can you please state your name?
Anthony Alfaro Callejas.
All right. What are we doing today on these?
Your Honor, we're
My counsel reached out, we have a discovery, technical issue that we're trying to resolve, so I wanted to get on ahead and entertain. I believe, we are requesting an adjournment. I did extend an offer, which he has, discussed with his client, and they're still considering that as well.
that is correct, Your Honor. We're waiting on a little bit of discovery left over. We would ask for this to be reset. And also when we're done, I'd like to make an amendment to the bond that you granted at the last hearing.
Probable cause conference, August 14, 2025, 9 a.m. As to bond.
Your Honor, you granted home confinement at the last hearing. My client has went to that location. It is quite a distance from where he's working. He has a friend that lives much closer to where he works. I think it's about 15 minutes away. It's a walk for him. And I provided an amended bond order that I sent over to your office, also to the prosecutor's office, so they could see that as well. There's the new address of, I believe it is 4822 Washington Avenue, Unit 15, Ann Arbor, Michigan, 48108. So we just asked that you would amend the bond to allow him to reside at that address for work purposes.
Any objection?
Okay.
All right, I will sign your order on that, counsel.
Thank you, Your Honor.
All right, thank you. Bond will continue in all other aspects.
Thank you. Have a nice day.
All right, you too. Hold on now. Court does call the case, people versus Marvin Sullivan.
And so we're coming on behalf of the people.
Morning, Your Honor. Michael Vincent on behalf of Andrew Sullivan. Hey, good morning.
Your name, sir?
Marvin Sullivan.
All right. Good morning, Mr. Vincent.
Good morning, Your Honor.
You're requesting an adjournment?
Yes.
Somebody's here with you. Good. How much time did you need?
A lot. Just for the court's information, over the night, we received 700 pages of a report. And more to, I believe we're picking up even more information from Pittsfield. My comment would be cooperative with discovery. The court should know that.
I can, the 19th, which is a Tuesday, or the following week, 28th, which Any objection from the people? Okay. Probable cause conference will be adjourned August 28th, 2025, 9 a.m. Bond in this case will continue. Court does call the case of People versus Amar Amadu. Amar Amadu. Who's on this? Shocking, it's canon. Come on. Welcome.
Thank you, Your Honor.
No. That was wrong. That was wrong on.
I messed up. Okay. Stephanie Cannon, on behalf of Mr. Amadu, keep your hands out your pocket. Your Honor, Your Honor, I am going to ask for an adjournment, and I will.
Are you?
Yes, yes, a 2-week
Took you
adjournment.
that long to
case.
decide?
I had to discuss something with my client, Your Honor, that's
just
all.
did that now.
Yes.
Okay.
Yes, that's the thing, yes.
How much time did you need?
I'm requesting a 2-week adjournment.
Are you?
Yes, please.
I bet you I don't have a green sheet.
You do not,
You are
Your Honor.
looking all around for one. One's not going to magically appear. We'll wait. Not long. August
I'll do one, Your
14th,
Honor.
2025, 9 a.m. Bond will continue. That's okay. Mr. Brown was filling one out for you, but
I appreciate it. I will be done, Your Honor.
thank you. Hey, they're bringing more? We don't have enough? What? Court calls the case of the People versus Mario Amoson.
Alexander on behalf of the people, Your Honor.
Robert, on behalf of Mr. Amoson, is approaching the podium. Amoson, please state your name for the record. Mario. So, Your Honor, there's a date and time set for probable cause conference. I was recently appointed. However, we are asking, I do not believe that there is video in this case, so we are asking that the matter be set for preliminary exam.
And if I could address Bowman, Your Honor.
Why am I not shocked? Okay. So you believe you have all the discovery?
I believe so, Judge.
Would the people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination, August 12th, 2025, 9 a.m. That is before Judge Freshour. Yes, ask the bond.
Your Honor, it's come to my attention that Mr. Amoson has called the victim in this case 100 times since his arraignment. So at this point, I would be asking.
What? 100 times?
100
Hold on. Okay.
Let me talk.
So I would be asking that his phone privileges be revoked. It's her listed number in this report as well.
Response?
So, Your Honor, I spoke with Mr. Amoson in the jail recently. We went over the no contact.
That wasn't on the phone, was it?
No, Judge.
Kidding.
Well,
My bad. Go ahead.
technically, it was, Judge. It was through the glass. So we did have a discussion on it. I explained that the no contact order, even if he receives contact from the complaining witness, he's not allowed to respond. Or to, I don't know, I got it. Or if he is, even if she wants contact, it's my understanding that she does want the no contact order lifted, but we did explain what it means to have a no contact order in place. And going forward, I'm confident he will not be making any more contact and reaching out to the victim at all.
Excuse me, can I talk, man?
What do you want to say?
She came and visited me, man. They let her come visit me, so it couldn't have been that serious of a non-contact.
So, you know, we did discuss what the no contact order means. And so at this point, we are asking we're already set for preliminary exam. So, and in the.
Domestic violence or nothing, man. It's fraud.
Okay, yes, we got it. You know, it's my understanding that the complaining witness has reached out to him several times, so that he didn't really understand what the no contact order meant. We've explained it. We've hammered down that no contact means no contact. And you know, so that at this point we are.
Well, let me ask this then, other than those times where the defendant's alleging that the victim has come toward him, are the phone calls his calls out to her?
Your Honor,
Some are from his pin and some are from other pins.
Well, I understand that, Mr. Burdell, there might be a mix-up when she comes there and.
I got one more thing to say, man. You ain't wearing it right, man. Excuse me, can I talk? I know how to talk. You feel me? I got you. She came
Sure,
to,
go ahead.
she came to the jail to visit me.
I heard you.
I haven't seen nothing, and mail said no contact. How is she able to visit me if it's a no contact order and I'm in jail?
That I don't know, and that's why I asked if there were, I'm trying not to take those contacts where she's making them with you into consideration, because your attorney just explained that you had a conversation about how you have to respond to that.
Then they
So
took,
then I asked, were there phone calls from or contact from you to her, which would be strictly prohibited?
right. Well, I was under the impression that I wasn't able to have no contact upon my release. They said during bond, we can't be in the same household. They never said about calling her from jail. This is not no domestic violence issue. This is a fraud for $30. That she clearly called the prosecutor and said she didn't want to press charges.
I don't know any of that, sir.
Like,
I don't.
because they telling you half the story, man.
I'm not gonna get that information right now. I'm not supposed to have that information right now. Anything else, Mr. Anything else, Mr. Burdell?
no, Judge, not at this time. Thank you.
At this time, and this is only for the calls that he's making now, either from his own pen or from other pens, because that is not allowed and strictly prohibited. Defendant's phone privileges at this time are revoked. You can make the argument before Judge Freshour to reinstate them after the preliminary examination.
Judge.
Thank you.
Thank you.
Man, you fired, man.
What'd you say?
Come talk to him, Mario.
You just want me to go? You don't want me to go? You want me to stop on that and say something? You just want me to keep going? Really? Okay. All right. Let's go. I'm gonna pick up the next one and just. This is on your advice, because I got something to say. But I'm not going to. Court calls the case, People versus Nathan Bell.
Assistant Public Defender Cosimo Vesi on behalf of Mr. Bell, but not with Mr. Bell. Nathan Bell? I have no explanation at this time. I had been in contact with him yesterday.
You were?
Yes.
How'd that go?
He wasn't on the bus, but we were gonna be asking for an adjournment, Your Honor. I have no explanation for.
Bench warrant, 10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. I feel better. Thank you.
So as he calls up the next contestant, good morning once again, everybody. Welcome to the Courtroom Files Live. Off to a fun start in Judge Simpson's court. If you are new to the channel and or you haven't noticed yet, this week we added a fun thing, tcfbingo.com. You can play bingo as you watch court. Mark things off on your bingo card as you see them. There's a leaderboard so you can see how you're doing against others. It's good fun, so check it out. There is a link to it in the pinned chat.
Your Honor, there's some outstanding discovery that I'm looking to collect. I'm asking for a few weeks to review everything. There are 2 different matters and search warrants and lots of reports. So I'd be asking for possibly the 28th of next month.
Is he held on anything else?
He is being held. I also have supplied the court with a consent order for a release to treatment and a reduction.
I signed that.
Okay. Nothing else is holding him.
Any objection to the 28th? Probable cause conference, August 28th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the people versus Robert Gaylet. See, and, yeah. Got it.
Introduction of any of the people. Bob.
Asa Bashir for Robert Gaylet on matter.
Oh, I'm sorry.
Thank you.
Good morning, Roger. On behalf of,
Could you state your name, please?
Robert Gallant.
Okay.
Judge, I apologize. Ms. Riser, may I approach with her? She's.
Give it to Alan. Your request, both of you are requesting an adjournment.
Yes, Your Honor. We're still working with Avalon, trying to get housing. We have phone calls in the works, Robert.
And we'd request, it's possible to have a 1 week adjournment. I believe Mr.
If it's got to be 2 weeks, she's going to cover for me. I have a circuit court trial.
Someone from my office, Mr. Yeah,
What?
there's a trial. Mr. Killawald has a trial in 2 weeks, so it'd be possible to have a 1
Why don't we
week
see
adjournment.
what date he's picking, adjourn it?
Probable cause conference, August 14th, 2025.
Go with that.
9 a.m. Bond will continue.
Thank you, Judge, for
Thank
your
you.
understanding.
Court calls case of the people versus Mik Wallace.
Ellie said on behalf of the people, Your Honor.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Wallace. Mr. Wallace, could you please state your name for the court?
Mik Wallace.
Your Honor, we're asking the court to please set this for exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available to 12.
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Eduardo Benavidez.
Victoria Burton Harris, she's the assistant prosecutor appearing on behalf of the people.
Oh, no, I'll wait. Eduardo Benavidez.
Conversing with the client on one last matter was coming up.
There was an issue that came up. I'd ask.
There was an issue?
Yes, sir.
Is that Miss Akinruli?
Yes, yes. It's. Yeah. No, she's not.
Oh, she's not the issue?
She's not the issue. Never.
Where is she?
Never.
Oh, Your Highness.
Good morning.
They were talking bad about you. I had
Not
your
Mr.
cover.
Brown, though.
Yeah. Oh, no, Mr. Brown was saying the worst stuff. He said you had issues. That's how I heard it.
You'll show me.
Apparently they didn't finish.
Assistant Public Defender Tanat Akinruli, Your Honor, on behalf of Mr. Benavidez. Mr. Benavidez, state your name for the record, please.
Eduardo Benavidez.
Thank you.
Judge, we're asking for an adjournment today.
All right. Will the 14th work for you?
That should be fine.
All right. During the matter, August 14, 2025, 9 a.m. bond continued.
Thank you.
Thank you. Let's call the case of the people versus Brandon Bowman.
Haley's on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Constable Bass on behalf of Mr. Brandon Bowman, who's present to my right. Can you state your full name for the record, please?
Brandon Charles Bowman.
Today's date and time set for a probable cause conference. At this time, respectfully requesting you set this for an exam.
And if I could address bond, Your Honor.
Are you going to address the conditional bond violation report that we have? There's something else?
Yes.
Oh, lovely. All right, you want it set for exam
Yes, Your Honor.
and you have the discovery.
To my knowledge, yes.
Would people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. before Judge Fresh Hour. As to bond.
Your Honor, I believe the defendant is in custody on a no contact order of bond violation originally. After he was put back into custody, he's tried to contact the victim 21 times. None of the calls have been successful, but he has tried to call her listed number in the police report. Since being put back in for violating the no.
And at this time, what's his bond? Is it revoked?
I have it as denied, Your Honor.
Yeah, that's what it should be. All right. As to that,
Your
Mr.
Honor, I haven't seen anything about these calls. My client is saying that he's.
I have not made one phone call.
Your Honor, he's going to be asking for a PR bond. He's been in for 8 days.
Is the phone calls that he made, is that attached to his pen?
Your Honor, I'm trying to pull it up my internet and not.
Okay. I understand you're saying that none of the calls were completed, but were they made from his pen? That's what I'm trying to figure out. Well, why don't we do it this way? Mr. Obasi, you can talk to the prosecutor's office regarding that. If they did come from, I'm gonna, at this time, I'll revoke his phone privileges. I will reinstate them if they did not come from his pen. Okay, so get with the prosecutor's office and I should have that answer as soon as their internet goes back up. All right, sir? All right. Otherwise, bond will continue as denied.
Your Honor, we have it pulled up.
Oh, you do have it? Hold on.
They're from different pins.
They're from, are any of them his?
No, they're all different pins. There are 2 different pins that are being used, but not this.
And none of the calls were connected?
Correct.
All right. I'm gonna deny the request then to have his phone privileges revoked at this time.
Your Honor, my client is asking for a PR bond. He's been in for 8 days.
I have a conditional bond violation. That's why he's in.
I understand. He's willing to admit to the bond violation and ask for the 8 days without a hearing. If
That I would not be sentencing him to the 8 days on it. for
Understood.
bond. I can tell you that. So does he still wish to admit to the violation? Yeah. Well, that's okay. Yes, I need one for different.
Okay. Okay. Understood, Your Honor. Then we'll keep it as it is.
Sorry. Once I check your history. Yeah, man, I'm just a figurehead. Court calls the case People versus Anthony Miller. He's in.
Your Honor, Alexis Pluma appearing on behalf of Mr. Miller.
Mr. Miller, can you state your name, please?
Anthony Lavelle Miller.
Thank you.
Your Honor, I am going to ask to address bond first, if you would allow it.
It's gonna have to be brief.
Okay,
Otherwise, you're gonna have to file a written motion, show back up at 4.
okay, understood. Briefly, Mr. Miller's bond was originally set because he failed to appear for a hearing last fall. I do have proof here that Mr. Miller at that time was incarcerated in the Wayne County Jail. He was in from September 2024 to April 2025. He would like you to consider a personal recognizance bond on his behalf because he has a part-time job.
How did he come back into custody?
I believe he was picked up.
So he
From-
didn't walk in after
from-
he left his time in jail?
He was in Wayne County, then taken to Oakland County, then transferred here. So he was released from Wayne County at the end of April of this year, then went to Oakland, and then was transferred here. So he was not out of custody at any point in time.
That's what I'm asking.
Yeah.
Said he was picked up.
Picked up from another jail, is I guess what I
Oh,
meant
okay.
to say. And he would be staying at the Delanis Center if released, but he does have his sisters who live in the area.
Any response from the people?
Your Honor, we can leave it in the court's discretion, start with the retail bond, so he's in custody. This isn't his fault. I mean, retail bond.
What was his previous bond set at?
He had a personal recognizance bond prior to failing to appear last fall.
Why do I have 25,000 cash surety? Well, doesn't matter. I'll grant that motion. I'll set his bond at $25,000 personal recognizance bond previously declared.
Understood. And Your Honor, I do have a green sheet for him. We're just requesting a 2-week adjournment.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continues.
Okay, everybody, for our nature/animal scene this morning, I have this. This comes to us courtesy of Kit Kat Playroom. A bunch of kittens looking like they're having some fun today, so we'll keep an eye on them between the different proceedings or when we just need a mental break, because sometimes that happens too. Let's switch it up a little bit. Let's go say good morning to Judge McNally.
Your name?
Mitchell Wilson.
What are you driving like this for? You just don't qualify. You got 4 prior moving violations on here. I'm sorry.
Yeah, I was trying to get it down to.
Yeah, well, you're not gonna get that from me.
Okay.
Okay, so you can go talk to him again, or you can request an informal hearing.
Okay.
What do you want to do?
Um,
You gotta be careful driving.
I don't know, I went through a stop sign.
You want to go talk to the department rep again?
Yeah, do I just knock on that door here?
I'll have the file brought over, okay?
Okay, thank you.
All right, Otero, Davidians, Jose Otero, 25T6460446A and B. Your name?
Division of Jose Otero.
Good morning. You're charged with animal violation, no license, that's a misdemeanor, and then you're also charged with grunt dog at large. That's a civil infraction.
Yes, sir.
You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
No.
I'm gonna go ahead and arraign you and then I'll send you to the prosecutor. It's alleged that you did own a dog that was on Cleveland near New York Street in Trenton at 2:20 PM on July 7th of 25. That is a misdemeanor, no license, punishable by up to 500 fines, 90 days jail, costs, or all those, and then the dog at large is a 0-point civil infraction. You understand that?
Yes, sir.
Now, on the misdemeanor, these rights apply. Did you sign the advice of rights?
Yes, sir.
Did you read it and understand it?
Yes, sir.
If you plead guilty at any time, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right. You still wish to waive your right to a lawyer?
Yes, sir.
I'm entering a not guilty plea. I'm giving you a $100 personal bond. Your dog, what kind of dog is that?
Pit bull.
Dog is remained in fenced-in yard or your house or on a leash, listen to this very carefully, or on a leash equipped with a muzzle. You understand that? A muzzle, do you understand that?
Yes, sir.
So do not have that dog out of that yard or out of your house without the dog being equipped with a muzzle, on a leash, and accompanied by you. Do you understand that?
Yes, sir.
You need to be accompanied by you, the owner, or other suitable adult, okay?
Yes, sir.
Also, you cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. So I'm going to hand this off to the court officer who will take it to the prosecutor and you'll meet with the prosecutor. Any questions?
No, sir.
And I'm entering a plea of denial on the civil infraction. Good luck. We still don't have that lawyer here?
No, I'll try to call him, Judge.
Please, thank you. Marcus Adam Ledyard, 25B1477098. Could I have Reg Winder Chahal seated at this table, my right, your left? And also Manuel Quatrin Velez seated at that table, right there at that table. Your name, sir?
Marcus Ledyard.
You're late.
I wasn't late.
You're not late?
It's at 8:40. I was here.
You're supposed to, you guys can have a seat. Seat. There you go. $75 a week you were supposed to pay, right?
Yes, I was.
Hang on. What did I tell you when I gave you that payment plan when you were supposed to pay $75 a week starting April 7th? What did I tell you?
So, hey, a few things happened, but,
What else did I tell you? If you didn't have the money.
I'll call you and let you know. To call the court now.
Call me, call the court, we'll get on Zoom and I'll give you an extension. Right?
Yes.
Or come in and talk to me on or before the due date and I'll give you an extension, right?
Yes.
Why didn't you do that? It's not that hard.
I just had a few things happen.
That's okay, I get it. That's why I tell everybody, you don't have the money, come to court and talk to me on or before the due date. How much do you have today?
Like 160, maybe something like that. 160.
Can you pay that today?
Yes.
Now listen, I'm
How
gonna
much
give
do I
you,
owe total now?
you owe 281. I'm gonna give you a payment plan, but you gotta show some respect and call the court if you don't have the money. Is that fair?
Yes.
Okay. You pay 160 today, and you tell me when you can pay the balance. How about if I set you, how about if I set you up on 40 per week? If you can pay it earlier, that's fine. Beginning August the 15th, how's that? You can do that, you think?
Yes.
If you don't have the money, what are you gonna do?
Call it court.
And we'll go on Zoom, or you can come in, Your Honor, before the date, okay?
Yes.
All right, best of luck to you. So go down the hall, pay 160, then 40 a week starting in, on August the 15th. Best of luck. Rajwinder Kaur Chahal, 25T645897. Good morning.
Good morning, sir.
Your name?
Rajwinder.
You're charged with just not having your license on you. And I can read the charge, send you to the prosecutor, or I can give you a lawyer, whatever you want.
Sorry.
It's okay. You have the right to a lawyer. If you want me to give you a lawyer, I will give you a lawyer.
No, sir. I don't mind.
Okay, so I'll go ahead and arraign you, and then you can go talk to the prosecutor. Is that fair? I'm gonna explain the charge and the possible penalties, and then you go talk to the prosecutor. I'm sure the prosecutor's gonna be reasonable with you, okay? Fair enough? You understand that?
Yes, sir.
On June 26 of 25, the police think you didn't have that you were operating a motor vehicle and that you didn't have a license with you on your person on Fort near Vreeland and Trenton at 12:32 in the morning. That is a misdemeanor. It is punishable by up to $100 fines, 90 days jail, costs, or all of those penalties. Do you understand that?
Yes, sir.
Did you sign an advice of rights and read and understand the rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
You have the right to a lawyer. You still wish to waive your right to a lawyer. You still wish to give up your right to a lawyer.
No, sir.
You want a lawyer now?
No, sir.
So you waive your right to a lawyer, right?
Excuse me?
You're giving up your right to a lawyer, right?
Lawyer? No.
Okay. So I'm gonna enter a not guilty plea. I'm gonna give you a $100 personal bond. You don't have to post any money. We're gonna send you to the prosecutor. You're gonna go talk to the Trenton City Attorney. I'm sure they're gonna be reasonable with you, okay?
Okay.
So you can go out in the hall. My court officer will bring this file to the prosecutor and they'll call you out, okay?
Okay, thank you.
Do you understand?
Go have a seat in the hall.
Hang on one second, hang on one second. Here. Stand right there, stand right there. I want to make sure you understand. Do you understand everything that's going on here?
Sir,
I just explained to you the charge and the possible penalty.
passport?
Possible penalty. I told you what the possible penalty is, right? I said it was, I'm just telling you what it is. It's up to, I'm just telling you the maximums. I have to tell you the maximums. Up to $100 in fines, up to 90 days in jail, plus costs. I don't want to scare you. I'm not going to send you to jail, but I have to tell you what the maximums are. Those are the worst things that could happen, but they're not going to happen. I'm not going to send you to jail because you didn't have your license with you. So go talk to the prosecutor, see what you can negotiate with the prosecutor. They'll write up a plea form, and then you'll come back in front of me. Okay?
Okay.
You understand that?
Yes, sir.
All right, good enough. Good luck. Courtroom. Manuel Ivan, Courtroom Velez.
Go have a
to the
seat.
podium, 24F243-103A. Good morning. See, he's got
Man, have a seat in the hallway.
hallway, man.
Grab your stuff.
You have to go talk to the prosecutor. So they got to go to the Flat Rock prosecutor to have him dismiss this, John. Go out in the hallway and the prosecutor will talk to you. He'll fill out a stip form, he'll send it in, and then I'll recall you, okay? Ross. Deviante Z1 Ross, 25T645998A and B. Your name? Deviante what? You're charged with driving on a suspended. You also have a expired plate. That's a B file. You have the right to a lawyer. If you want one, I'll give you one. Do you understand that?
Yes.
Do you want a lawyer? I'll go ahead and arraign you, and then I'll send you to the prosecutor. On July 8 of 25, The police think you were operating a motor vehicle on Fort near Sibley and Trenton at 9:13 a.m. That is a misdemeanor, punishable by up to 500 fines, 93 days jail, costs, or all those in 2 points. Do you understand that?
Yes.
Did you sign the advice of rights?
Yes.
Did you read it?
Yes.
Did you understand it?
For the most part, yes.
I can't hear you.
For the most part, yes.
Okay, so tell me what part you didn't understand.
Um,
If you plead guilty, we're not going to have a trial. Do you understand that? If you plead guilty, you're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. You're waiving your right to remain silent. You're waiving your right to a trial of any kind. Do you understand that?
yes.
All right. Now, if you plead guilty, you understand there will be no trial. You're giving up your right to a jury trial. Do you understand that?
Yes.
Do you still wish to give up your right to a lawyer?
Yes.
I'll enter a not guilty plea, $500 personal bond, okay? You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm going to send you over there to the prosecutor, and you'll come back in front of me either way. I'm entering a plea of denial on the expired plate charge, okay?
What does that mean?
That means I'm saying you didn't do anything wrong, to put another way. And you go negotiate this with him. He'll be fair with you, okay? Good luck. Segova? I got a note here, does not speak English. This is file 25T645-763 A, B, and C. Hola.
Hola.
What's your name?
Woodhaven.
I know, you speak Spanish? I'm gonna get you an interpreter. No, I know. We're gonna get you a Spanish interpreter, okay? I don't know how we can do that. I'm gonna reset the arraignment and pretrial. I need to learn how to speak Spanish, you know that? A little bit, enough to.
In-house interpreter.
Yeah, I know,
Every day.
we're getting a lot of them. Listen, Spanish interpreter, Espanol, listen, I'll get you one. Translation, I don't know what to say. Amy, point out the date to him. Try or have somebody try to explain. I'm gonna get him an interpreter and I'll just let you get the new date, okay?
Yep, Judge, we use Google Translate. It works pretty well at the window, so.
Perfect. See, I learned something today, John.
Yeah.
We have that down there. Go down the hall, all the way to the end of the hall. Thank you. Good luck.
Thank you.
Nicole Marie Mayros, 25T64667. Be right with you. Your name?
Nicole Maris.
You're charged with no license. On the dog.
Yeah.
You have the right to a lawyer. If you want one, I'll give you one.
I don't think I need one.
I'm going to go ahead and advise you, on July 8 of 25 at 1:17 PM, it is alleged that you did have a dog that was on Jackson Street near Benson and Trenton that was not licensed. You got to get a license. That's a misdemeanor, punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, I do.
Did you sign the advice of rights?
I believe so, yes.
This document, did you sign it?
Yep.
Did you read it?
I mean, I haven't really read it, no.
Don't ever sign your name. What if we just had you sign over your house?
I didn't sign this one. Is this the one you're talking about? I signed the one that has like 4 spaces for a signature.
All right, let me just go through your rights. You have the right to remain silent. You don't have to say anything.
Okay.
You have the right to a trial by court or jury. You have the presumption of innocence. They have to prove you guilty beyond a reasonable doubt. If you plead guilty, you're waiving the requirement that they prove you guilty beyond a reasonable doubt. You're waiving your right to remain silent. You're waiving your right to trial. You're waiving your presumption of innocence. You're waiving the right to bring in your own witnesses and to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, again, you're giving up all those rights and there's not going to be a trial. Do you understand that?
Yes.
Now, do you still wish to waive your right to a lawyer?
Yeah, I believe it.
I'll enter a not guilty plea. What kind of dog is that?
Australian Shepherd, and I have just a dog I found in the city of Detroit on the street. I saved him.
Okay, hang on a second. You know you have a warrant out of this court? Are they checking these warrants?
That warrant is, I paid a ticket a couple days ago, and your guys' computer system was down because of the storm a couple days ago. So they were supposed to actually fix that for me.
Did you pay the ticket?
Absolutely, yeah.
Okay, well, this is,
I have the paper. and
hold on, I
papers.
believe you, I believe you.
Yeah,
The-
she doesn't have a warrant, Judge.
Yeah, this was run July 25th. Okay, I didn't know that you came in and paid it.
I hope they updated that though.
They will not have a warrant out for your arrest.
Okay.
Okay, so give me a bond sheet. I'm giving you a $100 personal bond. You cannot leave the state without the consent of the court or violate any law.
Okay.
You must appear in court as directed. You are going to have to keep that dog.
I actually have a question, if I can ask a question.
Wait 1 second. That dog is to remain in your home. To remain in your house. Fenced in yard. Or, and I realize there wasn't a dog bite here, but or on a leash equipped with a muzzle. And accompanied by you or another suitable owner.
Morning, sir.
Morning, good morning. Okay, in the meantime, I'm gonna let you go talk to the prosecutor. I'm entering a not guilty plea. If he doesn't give you what you want, then you come and tell me you want a lawyer, but either way, you're coming back in front of me. Do you understand that?
Yes, today?
Yes,
Just
ma'am.
a little bit?
Yeah, okay?
Yep, thank you.
Do you have a question?
I thought they were on a two-year license, but turns out they weren't.
Go tell the prosecutor all that.
Okay.
Okay? Good luck. Mina,
Okie dokie, let's check on our kitten friends. It looks like they're calming down a little bit. That kitten energy, it just all gets expended at once and then they all collapse. So we'll, again, keep an eye on them. Let's go to Judge Glazer, see how she's doing this morning. I got to step out of the studio for a couple of minutes, but I will be back. Ashley, you can be in charge, and I'll be right back.
Grand theft.
Bien, primero, este vehículo no tiene ningún tipo de valor listado, así que es un delito de tercera categoría.
So Pedro Barrios reports the car stolen and
Pedro Báez reportó que se le habían robado el vehículo.
uses a fake Oklahoma title to revin the car and to title the car in her name.
Con un título falsificado de Oklahoma para poner el título bajo el nombre de ella.
So she's a bondsman here.
¿Y quién es el fiancista?
All right, I'll set a bond as follows. Count 1, dealing in stolen property. What do you want me to set that at?
En cuanto a
$1,000?
mercadería con propiedad robada, la
$1,000.
fianza que voy a aplicar va a ser
What do you want me to set
Okay,
that at?
Judge, it's fine.
$1,000, count 1. Count 2, grand theft of a vehicle is $2,500.
en el segundo, hurto de robo de un vehículo son 2.500.
Count 3 is the possession of a vehicle with an altered identification. What do you want me to do with all these? Count 3, set that at $2,500 and $1,000 arrest. What do you want me to do?
En cuanto a posesión de un vehículo con el título falsificado son 2.500.
Requesting 2,500 on count 3.
Okay. The
And
rest
then
1,000,
1,000
okay.
4.
Y el resto son $1,000.
What on count 4, 1,000 for the rest?
Maybe do one. And the last charge, maybe do one at 2,500.
All right, count 1 is 1,000, count 2, 2,500, count 3, 2,500, count 4 will be 1,500, count 5 is 1,000.
Bien. La primera acusación es $1,000. La segunda es de 2,500. La tercera es de 2,500. La cuarta son 1,500 y la cuarta son $1,000 de fianza.
Count 6 through 10 is 1,000 each.
Y del 6 al 10 son $1,000 cada uno.
All right. The bondsman's here, they'll get you out of jail, so that's,
El fiancista está aquí y lo ayudará a usted a salir hoy.
gracias. I
Thank
think
you.
it's 13.5. Have a nice day.
Que tenga buen día.
And there's probable cause for all counts,
Hay
except for
motivos para todas las acusaciones,
except count 2, which is a third-degree felony.
excepto el segundo, que es un delito de tercera categoría.
Yeah. Okay, next we have on page 1, I guess, is Diana Rodriguez.
The bond out,
Can you put this in the trash, please? Thank you. Bond out.
a good bond out day today.
I hope so. We deserve it. Next is Chelsea Dennis, page 1.
Present.
And she should qualify for pretrial.
1 minute. Thank you. Good morning, Miss Dennis. You were arrested for possession of a controlled substance and possession of cannabis. I will appoint the public defender's office for you. So there's probable cause for the charges. Pretrial services, alternate bond, $2,500, count 1. Do it. What do you want me to do for count 2? $1, ROR? What do you want?
ROR's fine.
ROR count 2. So it's pretrial 2,500 and ROR. Have a nice day, ma'am. Next, we have Lila Cunningham, page 2. Morning, ma'am. You were arrested for, it says indecent exposure, second or subsequent offense in obstructing a highway. I will appoint the public defender's office for you.
So Judge, it may be a misdemeanor because I don't think it mentions the prior offense. She potentially qualifies for a tap, but she's got to keep her clothes on.
She's dressed in a lewd manner.
She had a dress on, Judge.
Okay, but it was a see-through dress. It said her breasts and buttocks were completely exposed. It was a fishnet dress.
Well, they wear thongs all the time on the beach.
You got to cover the nipples, maybe, like there's certain areas that need to be covered.
I guess it depends who you ask.
In public, there are certain areas that need to be covered.
Okay. All right. There's probable cause for the misdemeanor indecent exposure. Does you have a place to stay, ma'am? Only 6 days. Where do you live usually?
I live in a hotel.
She lives in a hotel, Judge.
Tap alternate bond. Count 1 will be $150, and count 2 obstructing
a dollar for count 1. I mean, it's quite sexist that a man can walk around without a shirt on.
I agree with you.
Right?
Okay,
I mean, what's the difference?
yeah.
But nobody wants to see all that while they're driving on the road.
Well, you know what? There's a lot of stuff I don't want to see that I see every day.
Me too. $1 count 1 and count 2 obstructing the highway. I'll set that at $1. Tap alternate $1 count 1, $1 count 2. I'm going to give you a date to come back to court for the arraignment. What are we up to? September 1st. Is you sure that's not
No, that's Labor Day, I think.
Labor
No?
Day? I got to make my plans now to get out of this town. All right.
Judge, can you just ROR?
But she's only been in Miami, you said 6 days, and then she's also got an open and decent exposure, and it looks like she's
If
potentially.
she's been in Miami 6 days. When was the other one? From like last week?
I don't know. That
Last
was
year.
24. She does have priors out of state as well. Maybe TAP will at least try
I'm
and keep
giving her
tabs on
tap so they can try and help her get housing, maybe. Tap alternate $1 count 1, $1 count 2. Come back to court for your arraignment on September 1st. I'm sorry, September 2nd at 9 a.m. Courtroom 6-2 before Judge Altfield. Have a nice day, ma'am. Okay, next we have is Jasmine Saldana.
She may qualify for TAP.
Good morning, ma'am. Ma'am, you were arrested for possession of a controlled substance called crack cocaine and possession of drug paraphernalia. I will appoint the public defender's office for you. And English is good?
Yes, Judge.
All right. There's probable cause for the charges. TAP alternate bond. $2,500 count one. And count two will be $500. You have to come to court for your arraignment on September 2nd at 9 a.m. Courtroom 28. Have a nice day. Next case is Katuska Herrera. If there's anybody here for a case on Zoom, please type the name of the case you're here for. Can you repeat that in Spanish for me, please, Mr. Garcia?
Yes, Your Honor.
Thank
Si
you.
hay alguien aquí en representación de alguno de los sujetos, por favor ponga el nombre de la persona en la plataforma Zoom.
Is Miss Herrera coming up?
If we can just pass Ms. Herrera for a moment.
Okay. Next is Zunia Gonzalez, page 2.
Ms. Gonzalez is present. She speaks English.
Good morning, ma'am. You were arrested for possession of cocaine. I will appoint the public defender's office for you.
State's requesting a bond because she has 4 open misdemeanors.
Okay. She has 4 open misdemeanors. I got to set a bond.
Judge, would you consider the TAP program for her?
I'm not. I'm setting
Currently
a bond.
homeless.
I'm setting a
Utilize.
bond. I'll set her bond at $1,000. She has 4 open misdemeanors. They're set in October, though. Yeah, I'll give her a chance. Okay, they're not for drugs. TAP alternate bond, $1,000. Ma'am, you have, okay, you have to come to court for your arraignment on September 2nd at 9 a.m. Courtroom 3-4, Judge Block. Have a nice day. After the ladies. Thank you. Tamisha Mobley.
Bond out.
Thank you. Harris Jones, page 3.
Not aggravated.
Spanish interpreter, please.
Interpreter is present.
Good morning, ma'am. You were arrested for battery. It's charged with aggravated battery on a law enforcement officer and resisting an officer without violence.
Está aquí hoy porque la acusaron de agresión con agravantes a un oficial de las autoridades y también de resistirse sin violencia al arresto.
So I'm appointing the public defender's office for you.
Voy a nombrar al abogado de oficio para que la represente.
I need a moment to, oh, also for count 1, it's just battery on a law enforcement officer.
Si en la primera instancia se refiere a un caso de agresión física con agravantes a un oficial de las autoridades.
I'm setting a bond. It's 5,000 count 1 and 500 count 2.
En el primer cargo le voy a aplicar una fianza de $5,000 y en el segundo cargo será de 500.
Have a good day.
Que tenga buen día.
Next is Tamia Mobley.
Bond out. Judge, Ms. Jones does not have the funds for a bond. Would you consider any alternate form of release? I see no prior record for.
How long has she been living here in Miami?
¿Cuánto tiempo lleva viviendo en Miami?
4 años.
4 years.
Where are you from? Where'd
¿De
you live
dónde?
before that? Where's she
Antes de eso, ¿dónde vivía? ¿Dónde vivía antes de venir a Miami?
En la República Dominicana.
In the Dominican Republic.
Okay. State, you have an objection to house arrest.
Okay.
Si por un estado que se le aplique un arresto domiciliario, está bien.
All right. House arrest with a GPS monitor.
detención domiciliaria con un aparato de GPS.
Alternate bond is $5,000 count one and $500 count two.
Y la fianza alterna es $5,000 en la primera instancia y $500 en la segunda.
I'll do level 3 house arrest.
El arresto domiciliario será el tercer nivel.
All right, good day, ma'am.
Que tenga buen día, señorita.
Next is, sorry, you don't have, Katusha Herrera yet, right? I'll just pass in her case. You said Tamaya Mobley's a bond out. Can I call up out of turn Octavius Gallon on page 11? There's a victim in court. Is he there? He's not a victim? But why am I calling it? Are you the victim? Look, see, you're telling me it's a victim. Somebody in court for him, so I'm happy to call. Octavius Gallon, please. And then these are ready. Is he there on page 11?
Mr. Gallon is present.
Thank you.
Who
Good
is it?
morning. Mr.
morning.
Gallon, you were arrested for attempted throwing or shooting a deadly missile, stalking, and criminal mischief. So that's a first-degree misdemeanor. It's from May 22nd of 2024. I will appoint the public defender's office for you. I guess your friend's in court. Are you his friend? If a female friend of yours is in court. So let me review for probable cause.
So it's not an attempt. He actually threw the brick through the window, causing $250 worth of damage. And then he's been calling her multiple times, harassing, threatening her.
Okay.
Showing up unannounced,
Sir,
requesting plus house arrest.
you need to go to, this is from May, you need to go to family court and file whatever, a petition to determine paternity there if you're concerned about your son, unless you have an open case there already, and go see the family court judge. But I'm entering a stay away order from the alleged victim, Karina Torres. No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, her home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order, sir?
No.
All right. So count one, there's probable cause for throwing a deadly missile. That bond is $7,500. Count two, there's probable cause for stalking. That's 500. That's a first degree misdemeanor. What is that? It's 250, I think.
No, 500.
Oh, $500 for count two. Count three, criminal mischief. I'll set that at $500. And sir, stay away from the victim. Go to family court if you need to get a parenting plan and time sharing schedule. And you understand the stay away order? You get rearrested, you'll be locked up in jail until your trial.
Yes, ma'am.
All right, have a nice day. I'm not doing house arrest. This happened 2 months ago and he hasn't had anything else since. All right, he can post a bond. Now we're going to start with the men at 11 o'clock. Next we have is Joseph Sorrell.
He's requesting a bond.
Yep, I'm waiting for Mr. Sorrell.
Judge, on Mr. Gallon, he indicates he cannot afford the 10% for the bond. He has about $400 to put toward a bond. Would your honor be willing to, since it's a delayed arrest, to decrease the bond?
Okay.
Do a total of
That's fine.
4,000 so he can make his bond.
Okay.
Thank you.
Count one will be
$3,000.
$3,000. Count, thank you, Ms. Heath, I appreciate that. Count one is $3,000, count two is $500, and count three is $500. Good luck.
Thank you.
Next, we have Joseph Sorrell. I just gotta stand for a second. Gotta take my stretch break for a minute.
Okay, well, she takes her stretch break. Let's change it up. We'll go to Texas and see what's going on with Judge Stevens.
James, Alan Baker, that's you, sir? Yes, sir. Mr. President, your attorney, Mr. Crenshaw, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in a summary? Thank you.
Yes, sir.
In summary, sir, this indictment alleges that on or about May 5th, 2022 in Jefferson County, Texas, you committed the state jail felony of operating a motor vehicle in a public place while intoxicated with a child passenger, a passenger under 15 years of age. Do you understand what you're charged with here?
Yes, sir.
She doesn't know. This is normally a state jail felony, and looks like you are going to be pleading guilty to the lesser included Class B felony of operating a motor vehicle in a public place while intoxicated.
Class B misdemeanor, Judge.
Is that your understanding of the plan?
Class B misdemeanor, Judge. You said Class B felony.
I'm sorry, Class B misdemeanor. There is no Class B felony.
I was like,
Yeah.
headlights.
Yeah, sorry. But felony, very few cases we dispose of as a misdemeanor in this room. So you're gonna have to forgive me. I get into a routine. A Class B misdemeanor, which carries with it up to 6 months in the county jail and or a fine not to exceed $2,000. Do you understand?
Yes, sir.
Also, someone who is convicted of a DWI like this must serve 72 hours in the county jail. Do you understand? That's not it?
We're just proceeding on the lesser included of DWI first, which is a Class B misdemeanor, and there's no jail requirement.
Okay, what is this? 3 days to 6 months?
Oh, that's the punishment range if he was to be revoked on the deferred. The punishment range on DWI first is 3 days to 6 months.
Yeah, we're not worrying about that.
Oh, no, Judge, you're thinking of a DWI second, which has another 72 hours in the county jail.
Well, then, okay, this is reading here, 3 days to 6 months.
That's the punishment range.
And or a fine up to $2,000.
Yes.
Yes, sir. Everybody's square with that. Yes, sir.
I'm going to talk to him if they later money.
You understand that, sir?
Yes, sir.
You don't have.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up for how long can we do that? Up to 2 years?
2 years.
Yes,
That's the max.
and fine $500. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal if your case must understand.
I understand.
How do you plead to this lesser included Class B misdemeanor of operating a motor vehicle in a public place while intoxicated, guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No.
Without objection admitted. This goes on to state you are mentally competent to enter your guilty plea as freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses such as this that you have pleaded guilty to of operating a motor vehicle in a public place while intoxicated. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record without objection.
Without objection.
Pre-sentence report today.
Yes, sir.
I'm going to follow this agreement and find, sir, you have pleaded guilty voluntarily. You're mentally competent, so you understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer or postpone any finding of guilt so long as you follow these terms of conditions of probation. We call it deferred or unadjudicated probation. Deferred means it's postponed, but it's in your hands. All of these terms and conditions of probation. This is going to be 2 years or less. Do you do well, we can shorten.
We cannot shorten it.
We cannot shorten it. I can shorten the felonies.
Yes, sir.
But
You can't
no,
shorten it?
No, you can't. I can shorten most felony offenses, but the DWI related stuff is.
And I think we'll come back in a year, Judge, after he's been perfect on the
Yeah.
NFL, since you remove it. He's
Yeah,
had
there are
it for
certain things
3
we can do, but we can't, you're right, we can't shorten it because of the seriousness of the legislation behind all of that, which is for good reason.
For good reason.
It says Class A misdemeanor, but
It's a Class B.
it's Class B. Class B misdemeanor. And you're going to be placed on probation for 2 years. The probation office will go over these terms and conditions of probation. One of the requirements, you must complete a DWI education course as directed. And that's a good thing. Your insurance will go down. Plus, it's important to remind yourself about the importance of operating a motor vehicle safely.
Yes, sir.
Please see the probation office, do well, and it will be dismissed in, within 2 years, 2 years or less, okay?
Yes, sir.
All right, good luck, sir. Thank you.
Thank you.
And next is what, Caesar Lehigh.
Oh, that's maybe give me a minute, I can't do. That's fine.
2 years deferred.
2 years deferred.
Class B misdemeanor.
Caesar, come forward.
Okay, give me 2 more, same phone, just tap, not agreeing, tap it and tap it somewhere not there. One more, if I can.
I have two cases here, 23-41663 and 23-41664. The state of Texas versus Cesar Eduardo Lehigh. That's you?
Yes, sir.
Present with Mr. Finchard, your attorney and the state's attorney. Does the defendant waive formal readings of these indictments and arraignments here? Can we proceed in summary?
We can, Your Honor.
And we've got 2 of these.
Just on the first paragraph, Your Honor, just on the first in each one.
Okay. So we've got an evading arrest or detention with the use of a vehicle, a 3rd-degree felony in 41663, and then a felony DWI in 41664.
That's correct.
Exactly. Both are 3rd degrees.
Right. In summary, each of these indictments similarly state that on or about July 8th, 2022 in Jefferson County, Texas, in 41663, you committed the 3rd-degree felony of evading arrest or detention with the use of a motor vehicle. And in 41664, you committed the 3rd-degree felony of operating a motor vehicle in a public place while intoxicated. And part 2 of paragraph 1 or the second paragraph goes on to allege that you have 2 or more prior DWI convictions. So thus, every time you commit a DWI, it's a felony. And I see there's a prior conviction in each of these. We're leaving that alone.
Yes.
Right? We're, okay. So each of these are 3rd-degree felonies, which means you face a term of not more than 10 years or less than 2 years in prison in each case, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Agreements have been reached in your case where you would be sentenced to prison for 10 years. That would be suspended. You would be placed on regular probation for 7 years, fined $500. And there would be terms and conditions of probation, which are normal and customary for each of these offenses. Is that your understanding of the plan?
Yes, sir.
Good. 5, 6, 6. 41665. packaging for cameras. They have contract design for the kids. As a condition of probation, you're going to have to serve a few days in jail as a mandatory condition in the 41664 third-degree felony of operating a motor vehicle in a public place while intoxicated, a felony. Do you understand that?
Yes, sir. And Judge, we were asking if he can serve that on the weekends beginning August 15th and serve 5 straight weekends, please.
If I follow these agreements, and we're going to accommodate you, maybe better than you thought. We're going to follow, I'm going to follow these agreements. Do you understand what you're facing in each case?
Yes, sir.
All right. How do you plead in each of these cases? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And in 41664, the DWI third. How do you plead in paragraphs 1 and 2 here? That is the substance of crime and then the prior convictions in 2016 and 2018 in paragraph 2. Are all of those allegations in each of those 2 paragraphs true and correct as they are alleged?
Yes, sir.
Are you pleading true and correct to everything voluntarily and because it is true?
Yes, sir.
And you are guilty of each of these offenses?
Yes, sir.
To show you what's marked in each case as State's Exhibit 1, did you sign those documents voluntarily, understand them, discuss them with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 in each case tendered and dead.
So
without objection. This states in each of these cases you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You were guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence reports are waived in each case.
Yes, Your Honor.
Nothing further. I'm going to follow these agreements and find, Mr. Leha, you have pleaded guilty in each of these cases voluntarily, mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence from State's Exhibit 1 admitted in each of these cases to support your guilty pleas, to find you guilty beyond a reasonable doubt. And I find you guilty in each of these third-degree felonies. I am following these agreements. In each case, you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That will be suspended. In each case, you were placed on regular probation for 7 years. You will find $500 in each of these cases. In 41664, the DWI, you've been found guilty and true to paragraphs 1 and 2, respectively, of that indictment, which constitutes that third-degree felony. And you must serve 10 days in the county jail as a condition of probation. And you're asking for 5 consecutive weekends. I think the way the jail is working, if you were, well, that's fine. I think they can be done in three weekends and then 1 day. But we'll do it any way you want. But I think you can get up to 3 days credit if you check in on Friday and then they release you on Sunday.
That's how I always wanted it to happen. I'd heard in the past the jail was only given 2 days credit for that.
I don't know. I've not heard that.
24-hour periods of 24 hours.
Yeah, you check in by 6 o'clock on Friday night, you check out Sunday by 6. It's the hours counted and it's 2.
Okay.
It's not 3.
It has changed, so that's good.
And so the more I think about it, Judge, would you rather start these after Labor Day? Yeah,
it'll be on 5 consecutive weekends. check in on or before 6 o'clock. PM.
And why don't we start at, so that way you get beyond Labor Day. And Judge, if we could start those weekends on September 5th, that way he's not in jail Labor Day weekend. I know that's a difficult weekend for the jail.
You're thinking about the jail, I like that. Yeah, you're concerned. And that's okay.
Less chances of.
You ordered on that Friday after Labor Day. Okay. Anything else on this?
No, Judge, thank you very much.
Thank you very much. Okay.
Thank you.
All right, friends. While the cats are away, the birds will play. I have eyes on 2 different kitten cams from 2 different places, and all the cats are sleeping, but the birds are out, so they know what's what. Let's go back to Judge Simpson.
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth. So help you
Sure,
God.
I do.
State your name.
Name is Robert Martin Carl.
All right, sir, it is court's understanding you're going to plead guilty to the charge of use of cocaine. That's a misdemeanor, punishable by up to 1 year incarceration and a $1,000 fine plus court costs.
I want to be accountable for that, sir. Yes, sir.
What?
I want to be accountable for that, sir. Yes, sir.
Okay, so you understand the maximum penalties in the charge?
Maximum should be a year.
Will be up to 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, sir, I do.
All right. And understanding that, do you still wish to plead guilty?
Yes, I do, sir.
All right. You understand also, sir, that I will not, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Parr in the 14A2 District Court. You understand that, sir?
I never know that, but okay, sir.
All right. Did you want to discuss that further with your attorney?
My attorney.
You're gonna be sentenced in Ipswich.
Mhm.
Judge Barr, that's where all your other cases are.
Mhm.
So Judge Simpson's not gonna send you. Come back with me, Ipswich.
Or we'll just do it here.
Everything. Yes, sir.
All right. You want to proceed?
Proceed.
All right. So to that charge, how do you plead?
Plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
That is correct, sir.
All right. You signed an advice of rights form. Is that correct?
I did, yes, sir.
Okay. You have any questions regarding any of those rights?
No, I appreciate your consideration, and I'm accountable for the thing.
Okay. I need you to look at paragraph 5 on that form. You'll see a copy on the podium there. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir, I understand clearly.
You understand you're giving up your right to appeal of right.
That'd be part, yeah, no.
You understand that?
Yeah, I take that, yes.
Are you on probation or parole?
That's incorrect, sir. It's hard no, sir.
Okay.
I mean, no.
Okay, I'll try that again because I want to make sure the record.
No,
is
sir.
clear. Are you on probation at all at this point?
No, sir.
Okay. Are you on parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No promises made that I did not.
All right. Has anybody threatened you or coerced you in any way?
No, sir, they haven't.
You're doing this voluntarily?
This is the,
Okay, you're doing this of your own free will?
Yes, sir, that's correct.
All right. And you're also doing it because you believe that you're guilty of this offense, sir?
I am.
Okay, all right. On the date of March 27, 2024, at the location of 220 Pearl Street, City of Ypsilanti, Washtenaw County, State of Michigan, were you in possession of cocaine?
Yes, but no. No, yes, I was. I just go with that. But yes, I was.
Okay, let's try this again.
Yes, I was, sir.
Okay, let me ask the question. On the date that I just mentioned and at that location,
Yes, sir.
did you have cocaine in your possession?
Yes, sir.
Well, did you?
Yes, sir.
Okay, did you use the cocaine?
Given a chance, I would have.
Okay, so you didn't use it.
I did use it, I was using cocaine. I had cocaine and I was using
So you did use it?
it. Yeah,
Okay. Did you know what you were using was cocaine?
I was very advanced on that information. Yes, sir. Yes, sir. Keeping it simple.
So, sir, if any of what I just say is incorrect, let me know. On that date and at that location, you had cocaine in your possession, you used it, and you knew it was cocaine. Is all of that correct?
That is all correct.
Thank you. All right. Now, sir, I have to advise you that if between the time of this plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea, nor would the judge be bound by any evaluation in this case. You understand that, sir?
Yes, sir, I do. Correct.
All right, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right, and have I complied with the court rule and would it be proper to accept this defendant's plea?
Defense is also satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be August 13, 2025, 10 a.m. before Judge Barr.
And Your Honor, very briefly, if the court would consider a personal recognizance bond now that Mr. Carl has pled, he does have just recently got his own home in Ypsilanti through a VA housing voucher, and he is concerned about potentially losing that housing if he stays in custody. He does know what he would need to do in order to get out, and this is the only case that's really holding him. He does have other cases out of 14A2 with low nominal bonds set. He could afford to post those, but not the bond on.
I'm going to leave that choice up to, I'm going to deny the request at this point. I will leave that to Judge Barr, who will be able to take everything into consideration regarding this gentleman. So your motion for bond reduction is denied at this time.
Understood. Thank you.
Court calls case People versus Jerry Bigham. That must have been, he must have been at the time that one.
Andrew Bannis.
Austin Obese on behalf of the defendant, Your Honor.
Jerry Bigham, don't bang on my podium. What are we doing?
Yes, Your Honor. At this time, my client is wishing to waive his preliminary exam and seek an offer in circuit court.
Sir, is that correct?
Yes.
Do you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed?
Yes. Thank you, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
People also waive the right. Preliminary examination having been waived, defendant bound over to circuit court on both counts. Mr. Belvis.
Your Honor, we acknowledge the information. Thank you. At this time, my client waives formal readings and stands mute to the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
September 18th at 1:30, Judge Slay.
September 18th, 2025, 1:30, Judge Slay. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Sean Dorsey.
Andrew Children, on the other people.
Morning, Mike Gaddy, Assistant Public Defender on behalf of Mr. Dorsey, who's here to my right and beat me here by a mile. State your name for the record.
John Dorsey.
Your Honor, this is the first PCC. We are requesting a brief adjournment so that I've had a chance to speak with Mr. Childers so that we can continue to discuss this matter. We're also going to see if we can't work a release to a treatment in this case.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. Court does call the case of the people versus Michael Boyce Smith.
Good morning. Thank you, guys. On behalf of the people. I believe this is.
Yes, it's Miss Akin release case once again.
She was just reviewing the video.
What, she's reviewing what? Video?
The video of it, and she couldn't get it open, but ours open.
Oh, was she in with, were you in with your client reviewing video?
I was, Your
You've
Honor,
had
but
quite a week.
it's, I had, you know.
Yeah, I know.
Yes.
Because all of it's happened in front of me.
We've been
It's
together.
been a
all
mess.
week.
I'm surprised you're still standing.
Just hold it together, Judge. Try it. Good afternoon. No, it's still morning. Good
It's still
morning, Your
morning. Yes,
Honor.
it is.
Assistant Public Defender.
You want me to pass it so you can look at?
No, it's okay, Judge.
Okay.
Yes.
What would you like to do?
We would like to adjourn this matter. The court should be in receipt of a green sheet.
All right. Probable cause conference will be adjourned August 14th, 2025, 9 a.m.
Thank you, Judge.
Thank you. She's had a day. It's only been 2 days, but.
And I had a docket after we left.
What'd you say?
I had a docket after we left till 6:30 yesterday.
Did you? You are my hero. Court calls the case, people versus Robin Finney.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender with and on behalf of Ms. Finney, who is standing to my right. Please state your name for the court.
Yes, Robin Lee Finney.
All right.
And Your Honor, I am hopeful that we will be able. I did send over pretty substantial mitigation, including this newspaper article about all the work my client's done in the community to Mr. Childers. So he is reviewing that, and I think going to have a conversation with his witness. So we're asking for a brief adjournment.
Probable cause conference, August 14th, 2025, 9 a.m. Bond continue.
Okay, August 14th. We'll be in touch. Good luck. Thank you.
Court calls the case, people versus Savannah Bradley.
Corey Herbert, prosecutor,
And Laura Yagi, Assistant Public Defender with and on behalf of Ms. Bradley, who's approaching. In terms of the substance of the PCC, Your Honor, we're requesting an adjournment. Ms. Bradley is very eager to get into treatment. We have spoken, unfortunately, she works a lot, so we played some phone tag. I do want to address the bond issue.
So do I.
Yes. So initially, when I first spoke with her, she indicated that she was not aware that it was such a tight time frame within 24 hours of her release that she was expected to do an intake. She followed up with them, and she did make contact with them, scheduled an appointment. Unfortunately, she didn't realize it was the same time as a psychiatric appointment she had. So she went to her psychiatric appointment, and then she was basically calling them and calling me, waiting for them to call her back. There was a misunderstanding there. I think it was 2 days ago or yesterday, I told her, just go, don't even wait for them to call you, just go. And she was at work and she wasn't able to get there before they closed. So I did tell her first thing this morning to go, but by the time they opened, she was already here. So we are asking for the opportunity for her to go test today or for her to check herself in.
But after that point in time, she had no further contact with them.
So she is saying that she did call them repeatedly after the 23rd. I know that's not in their report, but that is what she is saying, is she called them and she left.
Very clearly says she failed to report for her intake appointment as ordered. No further contact has been made.
I understand that's what they say. She's saying she tried to call them. Her dad is with her in court today.
So, and when she tried to call them, what they say to her?
She left a message, I think.
And nobody called her back?
That's what she's saying.
Really?
I just want to make two other points. So first, she is a working mom. She is a 9-year-old. I believe she's sole care 9-year-old, right?
If she went over, would she test clean?
I don't know. I think so. I mean, based on my conversations with her, I will also
I
say,
think that's like a clearest question one can ask.
okay, she's saying she would test clean. And she's saying she is prescribed Adderall, and that's what she would test for.
And that's the only thing that's gonna show up?
Should, yeah,
Will or should?
will,
That's it.
yes.
I'll tell you what I'm gonna do. I'm gonna give you a shot. She needs to go over right now to community corrections, do her intake, take her test, and if you could let them know she's on her way over. If anything, tell them also that if anything comes, you need to come back over here. But if they get the test before you get back over here and something else shows up, take her into custody.
Understood. She is prescribed the medication, like I said, but
I heard.
understood, Your Honor.
Get over to community corrections. I'll pass the matter. Court calls case people versus Matthew Fonseca.
Good morning, Your Honor. Public Defender Carson Lubez on behalf of Ms. Fonseca, who's present to my right. Can you state your full name for the record, please, Matthew?
Matthew Fonseca.
Thank you.
Your Honor, today is the date and time set for probable cause conference. At this time, we're respectfully requesting to step for exam on both matters.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available the 12th. Preliminary examination, August 12th, 2025, in person, before Judge Valvo, in both matters. Bond will continue.
Thank you, Your Honor.
Court does call the case, people versus John Altcott.
Yes.
Stephanie Kane on behalf of Mr. Occult, who's appearing by Zoom. Mr. Occult, could you please state your name for the record?
John Paul Alcock.
Your Honor, at this time, we are asking that this be set for a preliminary exam.
Discovery is complete.
To my knowledge, yes.
And would the people have their witnesses available the 12th? Pardon?
That's fine.
All right. Preliminary examination in person, August 12th, 2025. 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Continue. Thank you.
Thank you.
Court does call the case of the people versus Nathan Gubachi.
Requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Ron Brown.
But you thought you had to be right next to her and not in the room?
Where you want me to leave?
Yeah. No, it's always a pleasure seeing you, Mr. Brown.
My pleasure, sir.
All right, so you just stay right there. All right, that makes me happy. All right, what are we doing on this case? Permission to practice it.
Thank you, Your Honor. We're requesting to adjourn this matter awaiting medical records for our office to receive his medical records.
His medical.
Yes, Your Honor.
I mean, I could put it out 2 weeks since he's in custody, but I don't, how fast are they?
May we approach? Prosecute.
Yeah, come on. Came up, that was what it was gonna end up being. Oh, what'd you say? I got it.
All right, well, he's muted. Let's go here. Our kittens woke up, and it looks like somebody's doing some cleaning in the room, but they're back in action, so that's cool. Spunky. Ellie used to be that way. Now she's off sleeping somewhere. I hope nobody has an Ellie square on their bingo card today, because she's missing in action once again. Silly cats. Let's go check back in with Judge Glazer as we get closer to lunchtime over there.
Morning, sir. You were arrested for possession of cocaine. I will appoint the public defender's office for you. There's probable cause for the charge and you're out on bond. There's a hold for you to see your judge tomorrow. It's setting the bond at $1,500. Have a good day. Then you have Daryl Burns, page 11. Good morning, Mr. Burns. Sir, you were arrested for burglary to an unoccupied conveyance and attempted criminal mischief. I will appoint the public defender's office for you.
Hey, Austin got a bingo. At least that's what the alert just said. So congratulations. Our official first bingo. Michael, you could still get one yet today. Good luck.
All right, so there's probable cause for the charge. Setting a bond. I don't know, State, what's your position on this one?
Requesting a bond.
He doesn't have a lot of priors. Do
He's
you
got a conviction from May, and then he's got a carjacking prison sentence.
Okay.
Judge, would you
Conviction
consider that?
Yeah, I'll give him tap alternate bond. It's $2,500, count one, and count two is $150.
Overstates objection.
Okay, sir, you have to come to court for your arraignment on what was it? August what?
September
sorry.
2nd.
Sorry, September 2nd at 9 a.m. Courtroom 28. Have a good day. Next is Cameron Ellis Johnson on page 12. Good morning, sir. You were arrested for attempted burglary to an unoccupied dwelling, resisting an officer without loitering or prowling. I will appoint the public defender's office for you.
So he's 18. It says he's homeless. Ms. Corey, where's his family? He can't stay anywhere.
Probable cause for attempted burglary.
Yeah.
The window screen in the rear of the home was removed. The plastic cover for the dog door had been removed. Sir, you are ordered to stay away from the victim YR and their residence at 1820 Northwest 188th Terrace in Miami Gardens, Florida. You are not allowed to go to that location. You must stay away from there. There's probable cause for the charges, and I'm setting a bond. It's not an attempt, it's a completed. He jumped over the locked wooden fence. I'll set the bond on count one at $5,000. Count two, resisting without, is $500, and count three, he should have been charged with I don't know if it's criminal mischief. Count three, loitering or prowling is $150. Good day, sir.
Mr. Ellis Johnson is currently homeless. She's just turned 18 not too long ago.
Okay, well, now he's in the
I- he-
felony
he
court and he'll see the
indicated to
judge
the
in
officer-
21 days.
He indicated the officer he's looking for somewhere to sleep, Judge.
Well, this is a residential area, and so he's looking for somewhere to sleep. That's his defense, and that's up to a jury to decide. There's probable cause for burglary to the unoccupied dwelling. It's not even an attempt. As he went into the curtilage area that's fenced in.
Judge, they're not indicating he was attempting to commit a crime inside, only that he wanted to sleep.
He removed the screen, the window screen, which is a criminal mischief. It could be that if it's,
I don't,
Ms. Court, does he have any family in Miami that he could do house arrest?
then he fled from the police. If he was really just looking for a place to stay, he would have just hung out and told them.
he may be able to go back home to his mom with an ankle monitor. Would your honor consider that?
Okay, that's fine. House arrest with a GPS monitor, alternate bond, it's 5,000 count one, 500 count two, 150 count three. Level, this is at 3:42 in the morning. Level 3 house arrest with a curfew from 11 PM to 6 AM. Have a good day, sir. Next we have is Yomar Basulto Galindo, page 12.
Qualify for pretrial.
We go to the next one. Does he need a Spanish interpreter?
Present, Judge.
Sir, good morning. Do you speak English?
Buenos días, señor. ¿Habla inglés?
Spanish, please.
Sir, you were arrested for possession of cocaine. I will appoint the public defender's office for you.
Fue arrestado por posesión de cocaína. Voy a nombrar al abogado de oficio para que lo represente.
How long have you lived in Miami?
¿Qué tiempo hace que vive en Miami?
2 años.
2 years.
Okay, pretrial services, alternate bond, $2,500. Have a nice day.
Servicios previo a juicio, $2,500 de fianza alterna. Que tenga buen día, señor.
Felix Gonzalez Dominguez, page 13.
Should qualify for pretrial.
Oh,
Bond out.
thank you. Bond out. Francisco Carrillo Corrio.
He received dollar bonds on his traffic case. He's also a fugitive from Collier County. Total bond is $2,000.
Thank you.
Spanish, please.
Good morning, sir. You were arrested for a
Buenos días,
case
sir.
from March 28th of 2025. The charges are burglary with an assault or battery and child abuse.
Usted fue arrestado por un caso de marzo del 2025 donde lo acusaron de escalamiento y abuso infantil.
I will appoint the public defender's office for you.
Voy a nombrar al abogado de oficio para que lo represente, señor.
There is probable cause for burglary with an assault or battery as, I don't know if it's child abuse or child neglect.
Right, I think the victim was holding the baby at the time.
Encuentro que hay motivo fundado para la acusación.
So,
Yes.
sir, you are ordered to stay away from the alleged victim, MM, and the child whose initials are ACM.
Y el señor se le ordena que se mantenga alejado de la víctima, cuyas siglas son MM, y del infantil, que las siglas son ACM.
No contact with the victims either directly, indirectly, in person, in writing, by telephone, or through third parties.
Ningún tipo de contacto con las víctimas, ni directamente ni indirectamente, ni por teléfono, ni por escrito, ni a través de terceras personas.
No contact with the victims through social media or other electronic means.
Ningún tipo de contacto con las víctimas, ni por las redes sociales, ni por ningún medio electrónico.
And you must stay at least 500 feet away from the victims, their home and school, and place of employment at all times.
Y durante todo el tiempo tiene que mantenerse alejado no menos de 500 pies de la víctima, donde sea que estén viviendo, trabajando o estudiando.
Do not engage in any criminal activity. Do not use or possess illegal drugs.
No tome parte en ningún tipo de actividad ilegal, ni puede portar ni poseer ningún tipo de drogas ilegales.
And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Ni porte, ni posea, ni compre ningún tipo de armas, ni armas de fuego, ningún tipo de munición para ellos.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court.
Inmediatamente tiene que entregar en la próxima estación de policía cualquier tipo de munición, armas de fuego, armas y permiso para portar armas ocultas y presentar un recibo de ello en el registro de la corte.
In the event there's an open case in dependency court arising from the same set of facts and events as this case.
Y en caso que haya un caso de la corte de dependencia que surja de los hechos en este caso,
Then any and all orders entered in dependency court regarding your contact, visitation, and custody shall supersede or replace this court's order.
todas las órdenes que surjan de ese tribunal van a sustituir a las órdenes que fueron emitidas en esta audiencia.
You understand the stay away order, sir?
¿Entendió, señor, de qué se trata la orden de alejamiento?
Sí.
Yes.
All right, I'm granting the state's motion for pretrial detention pending final hearing and holding you at no bond on count 1, the burglary with an assault or battery charge.
Bien, voy a conceder el estado a la petición en cuanto a la fianza y le voy a aplicar un caso sin fianza pendiente a próxima audiencia en el caso suyo.
So
Would you consider setting a bond in this case? It's a delayed arrest. The incident's alleged to have occurred back in March.
I can't
It's
do
not
that.
clear if he had permission. There's nothing indicating that she told him to leave.
No hay nada que indique que ella no le haya dado permiso, ni que le haya dicho que se fuera, y esto es un caso que surgió desde marzo. ¿Tomaría usted en cuenta eso para aplicar una fianza, señoría?
It says they're separated more than a year before the incident. There's probable cause for the charge and it's no bond count 1 and count 2 child neglect is $2,500.
En cuanto al primer cargo de escalamiento y agresión, no hay fianza, y en el segundo de abandono infantil, $2,500.
Good day, sir.
Buen día, señor.
Next we have is Alberto Mosquera, page 13.
Tenemos a Alberto Mosquera, próximo.
On down.
Thank you. Julio Armeda, page 14.
Let's change it up a little bit. We'll go back to Judge McNally for a while.
Going to be a plea to allowing an unlicensed driver to drive, the suspend to be dismissed. She has a valid license now, true?
Correct, Your Honor.
Is that what you want to do, ma'am?
Yes.
If you plead to that, that will not be reported to the Secretary of State. The possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes.
And did you sign, read, and understand an advice of rights?
Yes, it is.
If you plead guilty, you'll be giving up all those rights. There will not be a trial then. Do you understand that?
Yes.
To the charge, allowing an unlicensed driver to drive, how do you plead? Were you in control of a 2014 Ford that was being operated on Harrison near Nichols in Trenton on June the 9th of 25?
Yes.
And did you know you were suspended, revoked, or denied? Hang
Your
on.
Honor, we'll stipulate that at the time her license was suspended, although unaware of it, ignorance of the law is not an appropriate.
Good answer, Mr. Shimke. All right. All right, let me see this. Why was she suspended?
She had an outstanding ticket or some other scenario that she momentarily suspended her license upon receiving. I understand, Judge. She had made a payment on a ticket through Venmo. She thought that it had, oh, I'm sorry. She had thought she had renewed her license and.
Because she was suspended because of the impaired charge, right?
There was a sanction regarding her license. She had thought she had paid the reinstatement fee.
Right.
It didn't go through.
Right.
She had fixed it immediately.
Return payment suspension, I got it. All right, anybody force you to plead guilty?
No.
Please accept it, suspends, dismissed. Anything, Mr. Shemke?
Your Honor, she came here with a valid driver's license. I know that's the goal of this court. I respectfully request leniency in any admonishment.
100, anything you want to say? 100 fines, 125 costs, 75 victims' rights, $50 justice assessment. Totals $350 or 60 days, okay?
Your Honor, if possible, can my client get 30 days?
Does she have any money today? Where do you work?
A-Trade King Haven,
How much do you make?
15 an hour.
Let's make it 60 per week and I'll start it beginning August the 8th, okay? That's next Friday. You can do that, right? If you don't have the money, you call the court, I'll go on Zoom with you, or you can come in here on or before the date. I'll be glad to give you a extension, okay? Just don't ignore me, all right? Good luck. Thanks. 24F 243-103A. People against Manuel, Ivan, Quatrin, Velez. 24F 243-103A. Come on up here. Your name? Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God. You swear to tell the truth?
Yes, Your Honor.
Okay. You all right?
Yes, Your Honor.
Since you were in front of me when I sentenced you back on February 6th of 25, have you been arrested?
No, Your Honor.
Any new charges pending?
No, Your Honor.
Good job. You were compliant. Prosecutor moves to dismiss. You're all set. Case dismissed. I wish you well. Good luck to you. You're welcome. Robinson, have a seat up here, my right, your left. Mitchell, Jeffrey, Wilson, 25G306474. Your name?
Mitchell Wilson.
All right, so he's going to reduce it from a 3-pointer to a 1-pointer. You're going to plead to 5 over, right?
Yes.
To the charge 5 over, responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the original charge. Listen to me, Mr. Mitchell. Mr. Wilson. You like insurance companies? You want to give them your money?
No, and I haven't got a ticket in like 3 years. I was paying $9.54 and I finally got it down to $300 a month and I was happy with that.
Well, you had one in 19, 22, 22, and 23, so it isn't exact, and it was the latter part of 22. So I'm just telling you, you got 4 tickets on here, and that doesn't include anything that's not showing on here. You got to slow down. Speeds accepted, stop sign dismissed, 175. You can go down the hall and take care of that, all right?
Thank you.
Please slow down for your own sake.
I will have
We don't want you to hurt anybody or your good-looking face there, okay? Nicolian Chevalier Robinson. 24F 243-037. Mr. Robinson.
Good morning.
Long time no see. Not that long, though. How long's it been?
Maybe a month or two.
Yeah, I know. It's not that long, right? You got a show cause here. They think down the hall, the probation department does, that you violated probation in that you failed to refrain from consuming alcohol or drugs, testing positive on a chemical test on July the 29th of 25. July 9th of 25, my apologies. If you have no prior technical violations, if you plead guilty or if you're found guilty, you could get 5 days here. Do you understand that?
I don't understand.
Did you sign the advice of rights?
Yes, sir.
Did you read it?
Yes, sir.
Understand it?
I did.
If you plead guilty, you'll be giving up all those rights and there will be no hearing. Do you understand that?
Yes, sir.
All right. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
Yes.
I'll enter a not guilty plea for you. We will set this, you're going to go talk to the lawyer now. All right, and I'm entering a not guilty plea, and then you'll come back after you talk to the probation lawyer, which should be who? Looks like Mr. Shemke. Okay.
He's running attorney.
Okay, arraignment attorney / probation, I don't know. So you can go right out in the hall, you speak to him, you come back in front of me.
His name was Shemke?
Just have a seat in the hallway.
Shemke, I believe, yes. Anything else ready down there?
Okay, well, he's at a bit of a slow spot. Let's go back to Judge Simpson.
All right, our understanding is Mr. Halfacre is refusing to be seen.
Your Honor, that is the people's understanding, not only for today's hearing, but for his review with the CFP.
My information, he claims he has a presidential pardon.
I did not know it was a presidential pardon. I did
he
not
get
know
one?
he was a politician. Sorry about that.
All right, so what do you want me to do? Adjourn this?
Well,
I can't really do much if he's not here.
yeah, December 5th, you referred to a competency hearing.
I did.
January 10th, he was found not competent but able to regain competency. January 30th, competency hearing, a 90-day review set. April 11th, 90-day review report, still not competent. May 1st, competency hearing set, 90-day review due to competency update. July 3rd, competency hearing adjourned to allow 90-day review. And July 14th, update from Forensic Center, no update. Defendant refused to speak. I'm asking, he has grandparents who are interested in his well-being. I'm asking for some type of bond so he can get out of jail. He's been in there for months. It's a aggravated stalking charge of 5-year felony. But he's been in there for months now. So I'm asking for some type of bond that can be worked out.
Well, I don't really need a response because I might consider a bond if he were cooperative in the process, but I mean, I can understand, his grandparents, certainly they're concerned, but if he's not cooperative with this process while in custody, I'm not clear how that's going to happen if he's out of custody and we can't do anything.
I will contact the grandparents, see if some inroad can be made there.
All right. So what I will do is I'll have to, I mean, do they need a new order to see him? Do we know?
I can check one moment. I don't think so. I recall reading that they like, in their opinion, he remained incompetent until they learned that he hurt.
Got it. Well, right, his status would remain as it was on the original finding, so. Well, let's do this. I'll adjourn the competency review hearing. It's my last date in September, because he's got to see somebody and then a report. I'll set the review date to September 25th, 2025, 9 a.m. If we get a report before then, certainly we can move that date up.
Thank you.
Okay, thank you. Did Mike say he was giving me a party? Court calls the case of People versus Jordan Hartmeyer.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Jordan Hartmeyer. Please state name for the record, sir.
My name is Jordan Hartmeyer.
Thank you, Your Honor. To my understanding, discovery is complete, and I have reviewed and discussed that with my client. At this time, he is wishing to set this case for preliminary examination.
Would people have their witnesses available to 12? Preliminary examination in person will be set August 12, 2025, 9 a.m. before Judge Valvo. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Deontay Clifton.
Edward Drugas on behalf of Deontay Clifton.
Mr. Clifton, can you unmute and state, oh, there you go. Can you state your name, sir?
Deontay Clifton.
Thank you.
Thank you, Your Honor. There's some outstanding video that I'm looking to obtain. I'm asking for an adjournment. I am also now on the approved list, so I can speak with him up in the Newberry facility.
Okay.
I have court with him next week, so certainly I will have contact with him by then, but it's been about 2 weeks since I've been able to have contact with him, so.
All right, you want the 19th then?
I'd prefer if we could go.
I can do the 14th, but that means, are you going to be able to get everything you just said done?
I don't think by then. I'd prefer you had said which date?
Well, I can do the 19th or I can do the 28th.
I'd ask for the 28th.
28th. Any objection from the people?
Objection.
Probable cause conference, August 28th, 2025, 9 a.m. Bond will continue.
Thank you, Ron.
Okay, thank you. Thank you, Mr. Cliff.
You can give me a call. I'm on your approved list now.
Court calls case, People versus Robert Jameson.
Asli Bashir on behalf of Robert Jameson is approaching. And
Your name, sir?
Robert John Jameson II.
Thank you.
Your Honor, we're requesting the earliest available preliminary exam date,
All discovery is complete.
to our knowledge.
People have their witnesses available to 12. Preliminary examination in person will be set August 12th, 2025, 9 a.m. before Judge Freshour. Bond will continue.
Your Honor.
Thank you.
Court calls case of the People versus Lester Braggs, is it?
Michael Gaddy, assistant public defender for Mr. Braggs. I believe he's on Zoom, Judge.
Mr. Bragg, there he is. Can you unmute and state your name, please?
Lester Braggs.
Thank you.
Your Honor, we're asking for a brief adjournment in this matter. I believe we have it resolved. It's a matter of posting some restitution. I'd ask the court for 2 weeks to accomplish that.
2 weeks, he'll be able to do that.
Yes, he'll be able to post it in 2 weeks.
Exactly. Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
I'll be in touch, Mr. Braggs.
Okay.
Thank you. Court does call the case People versus Chad Jones, all 4 of his cases.
And Laura Yagi, Assistant Public Defender with and on behalf of Mr. Jones, state your name for the court.
Chad Jones.
And Your Honor should have a SIP and proposed order to release to treatment in his 4th case, which is the newest one. It's the first PCC for that case, even though it predated his arrest. He's been in custody for the past several
In
months.
his 4th case, which number on that?
The number is apologies, Your Honor. It is the 25 F5 5162.
Okay, I do see that. I'll sign off on that. That I don't have a problem with. All right. And then you want this, you're seeking an adjournment of these proceedings?
Yes, Your Honor.
How much time? I mean,
I think, I mean, he's going to court for Canton in just a few minutes to ask to be released to treatment on that hold. So hopefully a couple weeks, but I
can do the 14th or 19th.
I guess the 14th. Thank you.
You're welcome. August 14th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Calls the case of the People versus Dominic Brewer.
Andrew Manderson.
Assistant Public Defender Jay Bellinger on behalf of Mr. Brewer, who approaches. Mr. Brewer, can you please state your name for the record?
Dominic Brewer.
And Your Honor, I just got good contact information from my client who was recently released from a different county, so I'm just asking for some time.
Probable cause conference, August 14th, 2000. Well, why don't we do August 19th, a Tuesday?
Thank you, Your Honor.
2025, 9 a.m. Bond continue.
Thank you, Your Honor.
You, sir. Court does call the cases of the people versus Vincent Lambert. Wait, no, go ahead. I'm sorry.
Like a Fatima appearing on behalf of Vincent Lambert.
Your name, sir?
Vincent Lambert.
Thank you.
Your Honor, at this time, we are requesting for adjournment. We are awaiting discovery for 2 of the cases.
All right.
It's all right. I'm okay with bonding over at Funky right now. Okay. I'm just trying to speed it all up.
I'm gonna ask, yeah. Your Honor, we would like to address bond when appropriate.
Briefly, I will. Probable cause conference in these cases will be adjourned to August 14th, 2025, 9 a.m. All right, as to bond.
So we'd like to modify the bond to reflect a similar bond by Judge Kunke in circuit court.
What?
Like to modify the bond to reflect a similar bond to what Judge Kunke has ordered in circuit court for treatment.
Okay, so I'm supposed to guess on that, or what was it?
And Judge Kunke's courtroom is allowed to be released to treatment. He's on probation in those cases. And
So he can be released on a PR to treatment?
yes, Your Honor. The people wouldn't have an objection to a release to treatment if there was a tether. We do have some concerns that Mr. Lambert does have multiple cases in front of this court. Defense counsel and I have been emailing back and forth, and I think there's some more coming. But
More what coming? Cases?
Yes.
Oh, boy. So, do you have an objection if he's on a tether? Don't ask Brown. Do you have an objection
No,
if
we
he's
don't
on
have
a
an
tether?
objection. No.
Don't? Okay, so I don't have any objection to release to treatment for anybody. You guys just include the tether language in, and somebody will sign it. I mean, I'll sign it.
I have a question.
Sure.
When being released with tether, they require for you to have a phone. Is that going to be a requirement for treatment as well, even though I'm being released to treatment? Because you can't have a phone in treatment, but I don't have a
Correct.
working phone.
And that may be, so let me put it this way. If you have the tether and you guys can work it out, I'll sign the order either way. But that may limit his options of treatment.
No, I'm saying that I don't have a working phone in my property, and tether, the last time I was released, required for you to have a phone before you can.
Correct.
Okay.
And so that's going to cause a problem for you. But somebody may be able to solve that problem. The other problem that is caused is some facilities do not allow the tether and then do not allow the phone, which you would have to operate. Everybody got that? Okay, so he can be released to treatment on a PR, and I'll sign that order. I don't have a problem with that. And so his bond will continue with that modification. So, okay.
Okay, thank you, Your Honor.
Court calls the case People versus Anna Bowman. He's what?
Your Honor, Alexis Pluma appearing on behalf of Mr. Bowman.
Mr. Bowman, can you state your name, please, sir? Yeah, Mr. Bowman, can you state your name?
Need to talk to my lawyer.
Pardon?
Need to talk to my lawyer.
He
Mr.
doesn't
Bowman,
apparently want to state his name or follow the orders of the court. Go ahead.
I didn't
counsel.
hear you. I'm sorry. I didn't hear you. Dr. Adam Baldwin.
thank you. And Your Honor, I do have a green sheet here. We are requesting just a brief adjournment, and Mr. Bowman would also like me to address his bond if you would allow
Well, we
it.
started out on the right foot for that, but go ahead. Take it your best shot.
Understood. Mr. Bowman is currently being held on a $50,000 bond on this case. This is the only case that is holding him currently. He is asking the court to consider a personal recognizance bond. He doesn't have a history of failing to appear for court. He does attend all of his hearings. And primarily, his request is because he's currently enrolled in school at Wayne Community College, and is worried that he is going to default on his loans if he remains in custody, and also worried that he wouldn't be able to get another loan in the future because of this. He would stay away from the University of Michigan Hospital as well, which is where he was seeking psychiatric treatment when this incident occurred.
Response.
The people would request a bond remain as currently set. It's on it, it's on the sex offender registry, he exposed himself to staff at the hospital. There's in a lot of very explicit threats to staff, including threats of sexual assault, violence against them. Very well maybe related to mental health issues. Those are clearly not currently in checks.
Anything else? Ms. Fuller?
No, Your Honor, thank you.
Motion for bond reduction is denied. Bond will continue.
Thank you.
All right, friends. Well, speaking of doctors, let's talk about a company that has a PhD in online protection, and that's the sponsor of today's show, Aura. So I've been talking about Aura for a couple of days now. You guys know that. They came to me and said, hey, we want to sponsor your channel. I told them to prove it. They told me to Google myself. I was frightened with what I found, and then I started using their product before I decided to bring them on as a sponsor. But here's the thing. I'm looking live at my dashboard right now, and I'm not going to show it to you because there's personal information on it. But in the couple of weeks I've been working with them, they have removed my data from 23 different data broker sites with 12 more that they're currently working on. I've been removed from 7 different people search sites, 4 junk mailing companies, and 2 real estate data brokers of all things. Maybe because I've been doing a lot of research for Home 2.0 that we want to get to in a couple of years. I don't know. But it's 41 requests that have been completed so far and 12 more that they're working on. And the amazing thing is that these are 99% of them are companies I've never even heard of. I had no idea who they were and that they had my data, but Aura did. And that's kind of my point and kind of why I brought them on as a sponsor to this channel. It's an all-in-one shop basically for your online protection. Everything from identity protection to transaction monitoring, spam and junk removal, spam call protection, which has been a big one for me. They have a password locker to help you keep track of your passwords and make sure everything's unique and not shared between multiple accounts. They've got a VPN, antivirus, you name it, you're going to get it all in this one place. Now, the nice thing is I've arranged with Aura to get you guys a 14-day free trial. Just go to aura.com/TCF. There's a link down in the description. You have absolutely nothing to lose. Those 2 weeks aren't going to cost you a dime, and you're going to find out in those 2 weeks who has your data online and what Aura can do to help you. So it's 2 weeks, I say well spent, but you're not spending a dime. So there's really no reason not to give it a try. Aura.com/TCF. Again, there's a link down in the description, and I encourage you guys to give them a try. Support those who support the show, and quite frankly, help yourself. You'll be amazed at what they uncover for you. Let's go back to Judge Simpson.
So I'm going to adjourn your case out 2 weeks, which is the fastest that I can do it. We'll get that order down today, signed, and there'll be an attorney that will contact you, okay?
Okay.
All right, very good. So probable cause conference will be adjourned to August 14th, 2025, 9 a.m. Bond will continue. All right, thank you, Ms. Gargo. Court does call the case, People versus Nicole McCauley.
Asli Bashir for Nicole McCauley.
Nicole McCauley.
Thank you.
Thank you. And Your Honor, we have a green sheet.
All right.
We're requesting a brief adjournment just to confirm some information for further negotiations.
August 14, 2025, 9 a.m. Bond will continue.
Thank you.
Court calls case of the people versus Xavier Briggs Sumner.
Asli Bashir on behalf of Xavier Briggs Sumner.
Xavier Briggs Sumner.
And Your Honor, we are requesting an adjournment to review discovery in this matter, media discovery that we didn't.
Probable cause conference, August 14, 2025, 9 a.m. Bond continued. Calls case of the people versus Urbima Magbury. Oh, charity.
Assistant Public Defender Chinazi Carey-Akinruli on behalf of Mr. Urbima Magbury. Mr. Magbury, state your name for the record, please.
Thank you. I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of use of cocaine count. Upon his acceptance of that charge, count one would be dismissed. The prosecutor will recommend and have no objection to the sentence. The defendant is currently under VOP sentence by Judge Conlon and will be in the Washington County Jail until November.
That is correct, Your Honor.
All right. He has signed off on this. Did you mean to check the sentencing judge waiver box?
I did mean to check that.
Pardon?
Is it checked?
No.
Yeah,
That's why I asked.
I intended to check it.
Did
Your
you?
Honor. I
Okay,
did.
and I'll do that for you.
I appreciate that so much,
All right.
Judge.
May I have him sworn?
Ryan, you solemnly swear to the testimony about the guilt to be the truth, the whole truth, so help you God.
I do. State your name. Urbima Jamal Magbury.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that? You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced in the 15th District Court before Judge Valvo. You understand that?
Yes.
All right. Now, understanding all of that, you still wish to plead guilty? Yes? And to that charge, how do you plead?
I didn't hear you.
To that charge, how do you plead? Guilty, not guilty?
Judge, kill him.
Guilty? Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
You signed an advice of rights form, is that correct?
I did.
Any question regarding any of those rights? Please look at paragraph 5. Those are your rights. You'll see a copy there on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
June 23rd, 2023, at the location of 900 South Maple, City of Ann Arbor, Washington County, State of Michigan. Did you have cocaine in your possession?
Yes.
Did you use it?
Yes.
Did you know what you were using was cocaine? Finally. All right. Sir, I do have to advise you that if I accept your plea and between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rule, that you would not be allowed to withdraw your plea, and any sentence or recommendation or evaluation by the court would no longer be bound by. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements
No, Your Honor.
that have cost? You want to let me finish? You want to go ahead? That was your way of sort of preemptively saying that you're not aware of anything else.
We are not
All
aware
right.
of any other things.
Are the people aware of any threats, promises, inducements that have led to this plea?
People are not.
All right. And have I complied with the court rule and would it be proper to accept this defendant's plea?
And defense is satisfied as well, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be August 26, 2025, 9 a.m. before Judge Valvo. Bond will continue. Thank you.
Thank you, Judge.
She said that so nice. It's not like Ann. He's on June, Judge. Court calls the case versus Anthony Turner. I'm gonna let her know.
Maybe Richard McDuffie people.
Stephanie Can on behalf of Mr. Turner.
It's all just a surprise sometimes.
I couldn't hear you.
Yeah, it's okay. No, I'm just.
I couldn't hear you.
Mr. Turner, can you state your name, please?
Anthony Turner.
Thank you, sir.
And Your Honor, we have actually reached a plea in this matter. However, they didn't bring my client over, so I couldn't get him to sign the plea form. Your Honor, if it's okay with the court and okay with my client, I'd ask that I be allowed to sign it with his permission.
No, I'm not gonna do that. The plea form
Yes, Your
and
Honor.
everything.
It's all right here, Your
Has
Honor.
he read it?
We discussed it last week, but
Did you go through it in detail with him?
I could not, Your Honor. They did not bring my client, so no, Your Honor.
Well, where is he?
He is currently,
He's downstairs.
yeah, he's downstairs. I can go downstairs if you want to call it maybe later today. Is that okay?
Oh, no, that's not happening.
Oh, well, there's that.
There's
So there's that. There's that. Your Honor, I went to the jail to see him prior to getting the plea form.
I know.
So I'm
I
sorry.
get it.
Okay.
I get it. And you weren't able to get that and go through all of his rights and go through everything with him. I prefer that you do that. I will, although I don't want to, I will give you just a 1-week adjournment. Is he
Perfect.
held on anything else?
Nope, Your Honor, it's just this. He's going to
It's
mental
just
health.
on this one?
Yeah, he's going to mental health court. He's already been, it's all right here.
It's all been, okay, so let me do this. Let me kick it out 1 week.
No, it's not. Pay attention.
Thank you, Your Honor. What's the date you're turning it up to?
2025.
You see, he wouldn't let me borrow his pen. I'm
What?
like, you see how he wouldn't let me use his pen?
You didn't bring your own?
You know what, Your Honor?
Bond will continue. All right, thank you. Thank you, Mr. Turner. She'll be down to see you and go through those forms with you, okay?
Yeah.
All right, thank you, sir. Court calls the case.
I hope for that guy's sake that the plea deal he was going to sign didn't involve him getting out today, because you could see the look of shock on his face. So I'm kind of wondering if he was supposed to get out and now he's delayed a week, which would suck for him. Let's go to Texas and Judge Boyd.
Salas, can I have parties announced?
Rick Pena for the state of Texas. James Stoji for Salas.
And are you Ricardo Salas?
Yes, ma'am.
Let me put this in. All right, did you review the state's motion to enter adjudication of guilty and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilty and revoke probation with your attorney? Did you understand that?
Yes.
Are you the same Ricardo Anthony Salas who's placed on deferred adjudication in 2020 CR 10239 for the offense of assault, family choking, strangulation on February 9, 2021 for a period of 3 years? Is that you?
Yes.
Right. State?
This morning, we're here on state's motion to enter adjudication of guilt and revoke community supervision. Violation condition number 5, in Bexar County, Texas, the defendant, Ricardo Anthony Salas, did then and there failed to report to the supervision officer as directed for the months of August and September 2021 in violation of condition number 5.
All right, to that, how do you plead? True or not true?
On what he said?
Yes.
True, yes.
All right, so you seem a little bit unsure. So the state is saying that you didn't report for the months of August and September in 2021. Do you understand that?
Yes, she was the one that usually sent me a text or a call to let me know like it was on Zoom.
No. So here's the thing.
It's true. Or
Yes. So sometimes when people plead true, they plead true and then they say, hey, judge, no, I didn't report, but I have an explanation. You understand?
Yes, ma'am.
So you've heard states reading a violation of condition number 5 that they're saying you violated.
Yes, ma'am.
All right. To that, how do you plead? True or not true?
True.
All right. State.
For the original motion to enter adjudication of guilt, we will waive the remaining violations and we will now proceed on the supplemental motion, Your Honor.
All right.
Violation condition number 5, in Bexar County, Texas, the defendant, Ricardo Anthony Salas, did then and there fail to report to the supervision officer as directed for the months of October, November, and December 2021 in violation condition number 5.
How do you plead to that? True or not true?
True.
Violation condition number 5, in Bexar County, Texas, the defendant, Ricardo Anthony Salas, did then and there failed to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, and December 2022 in violation condition number 5.
How do you plead to that? True or not true?
True. Violation condition number 5, in Bexar County, Texas, the defendant, Ricardo Anthony Salas, did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, and December 2023, and violation condition number 5.
How do you plead to that? True or not true?
True.
Violation condition number 5, in Bexar County, Texas, the defendant, Ricardo Anthony Salas, did then and there fail to report to the supervision officer as directed for the month of January 2024 in violation condition number 5.
How do you plead to that? True or not true? And state, do you waive the other violations?
I don't believe there are any others on the supplemental.
Well, you're correct. All right. Any objections to the state's waivers to the other violations?
No, ma'am.
All right. Did you understand by pleading true to violations 5, 5, 5, 5, 5, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to 5, 5, 5, 5, and 5?
Yes, ma'am.
The court will find 5, 5, 5, 5, 5 true. Is there a proposed agreement?
There is not, Your Honor. We're both going to go open to the court for our recommendation.
All right, state, what are you requesting?
State requesting a revocation of defendant's probation, adjudication of guilt, and 3 years TDC.
And defense, what are you requesting?
Judge, I have well, obviously I have a different recommendation. I don't know if you want me to give it to you now. I have one witness that I would like for you to hear.
Oh, come up.
Is that okay?
Yes.
Okay, Mr. Ibanez, his name's Justin Ibanez.
Okay.
And as he's walking up here, I don't intend on calling all of them, but if you're here for Ricardo, can you stand up, please? I just wanted the court to know that he has his grandmother, mother, and siblings all here in court today.
All right, and what is your name, sir?
Justin Ibanez.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, and you can, if you can lower your hand. And you said Ibanez?
Ibanez, yes.
How do you spell the last name?
Ybanez.
All right.
And yeah, on top of the N too.
Okay. I don't know if the court reporter has that symbol she can put. All right, defense, do you have questions or did he just want to let the court know some information?
He does, Judge. I just wanted to ask him this one question. Just if you could tell Judge Boyd, how long have you actually known Ricardo?
Since elementary, last, if I could remember. Yeah, like 4th and 5th grade.
A long time.
Very long.
So
time.
you
Last
have
15 years.
Sorry, you have prepared a statement you would like to share with Judge Boyd about Ricardo?
Yes, I do.
Okay, good, you can do that.
Good morning, Your Honor, and the people of the court. I'm here today for Ricardo Anthony Salas and to tell you the type of man he is. We both grew up together most of our lives, and I can say he is one of the most hardworking men I've known. He's very dedicated to his family, a great family man. Not only have we grown up together, but we've had similar tragedies. Both of our fathers have passed away just months apart. And as we are here today trying to follow in our father's footsteps, to try not miss a second of our children's lives by sending them away for so long will not be beneficial for him or his family, as it can have an effect on his kids for the fact that he was always there, never missing a day of their lives, with Zoe doing cheer, Naya taking her to school every day, and being ultimate babysitter for baby Ricky. These past months have been very hard on the children, and I know that he can change his ways for the better, to be a better citizen and hardworking for his family and kids who he loves very much. Thank you, Your Honor.
All right, thank you so much.
All right, thank you.
All right. Any objection to my asking a question?
No objection from the state.
All right, so this is what I want you to realize, and I keep an open mind when everybody's on probation, right?
Yes.
Because sometimes people have things that happen, and I understand. Where has he been since 2020-21? Because we're in 2020-25, and I want you to understand, he's on probation.
Mm-hmm.
And the easiest thing to do is report. And I tell everybody, if there's an issue, you can always come to this court and discuss the issue with me. But according to what he's just played true to, nobody's seen him since 2021. And I understand when people are like, great, I'm living my life. I'm not picking up any new cases. But being on probation, there are conditions with that. There's no such probation where the probation is, you're on probation and I'm just going to disappear. Because otherwise, why do we have probation?
Yes.
So where has he been? Do you know?
He's been in the same place
Mhm.
since 2020, or he moved down the street to his dad's, and he's been working there.
But did you know he was on probation? Did he let you know that?
I did, but I thought it was dismissed because they stopped talking to him. They stopped reaching out.
Okay. All right. Thank you so much for coming in and giving me some insight into him. I really do appreciate it.
Yes, thank you.
All right. Thank you. Any other witnesses?
There are no other witnesses.
All right. You can come forward. All right. So, Mr. Salas,
Yes, ma'am.
I appreciate the fact that your family is here. I appreciate the fact that you have witnesses who are coming in to support you, right? But the easiest thing to do when you're on probation is report. I mean, that's easy. And so the issues with you is any objection to the court reviewing the court summary?
No, not at all. And I do have some comments for the court that I don't think appear in the summary at the appropriate time.
Okay. Well, I'm just going to give you my thought process. And then, of course, I will still keep an open mind, right? So the problem is nobody's seen you since 2021.
Mm-hmm.
And then according to the court summary, you haven't completed anything. Is there anything that you've completed on probation other than just, I didn't pick up any new offenses?
Just the family violence class.
All right, they're saying here that you have not completed the BIP, the parenting classes or outpatient treatment.
Okay. Can I just tell you my side of the story real quick?
Do you have any objections to? All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Boss.
All right, so why didn't you report?
All right, so we're 8 months into it and everything going good. And then I had my mom in the hospital from COVID. This is all during COVID. I had my mom in the hospital. I just had a newborn son, and then my dad passed away. I'm not trying to no excuse or anything, but
I just hoping for like understanding that I wasn't trying to like not report or anything like that. I was going through so much, Your Honor.
Well, so here's the thing.
Mhm.
You haven't reported since 2021. We're in 2025. So I do understand when people have family members to pass away, when people have family members very ill. I understand when COVID was going on, but you didn't even pick up the phone in 2022. All right, and COVID, okay. 2023, 2024. All you have to do was pick up the phone and call probation. I understand when people have issues that are going on in their life, but they haven't seen you since 2021. And according to this court summary, you didn't do the BIP course. This is an assault family violence case, so you need to do that.
Okay.
According to this, you didn't do the parenting classes and you didn't do outpatient treatment. So have you done any of those?
I started like 2 or 3 classes when I think of the Zoom meetings.
Mhm.
I'm not too sure how far. I know I started right away. And then being in jail, ma'am, I'm sorry. It opened my eyes to like I should have caught it. I should have done other things other than not caught.
Yeah, everybody, let me just tell you, a lot of people have an eye-opening experience when they go to jail or when they go to prison. They're like, now I see.
Yes.
But it's not as though you're a teenager, you're an adult, so it shouldn't take that.
Gotcha.
And everybody, you can't be on probation and not be on probation. And what I mean by that is you have certain conditions you have to follow.
Yes, ma'am.
And your condition can't be, well, I didn't pick up any charges. It's not like in municipal court where they give you deferred and they tell you just don't pick up any new cases and you'll be fine. Okay.
Can I,
Yes.
can I add on? a little
Sure.
bit? So I had the exact same dialogue with Mr. Solid Strike. He did tell me about his situation, and I think early on, he got off to a decent start. And then COVID did affect his entire family. He did lose his father to COVID when his mother was very, very ill, and as I understand, the probation department was there in the home. At one instance, the mother was very ill with COVID, and his father had already passed. The file documents all of this, and I asked Ricardo the same thing, like, I understand 3, 6, even a year of your life being so affected by your loved ones, but at some point, you're gonna have to come back into the fold. And as so often happens, I think you fall into a hole that's up to your knees and you just let it continue, and before you know it, it hits your chest. And then 2 years later, it's over your head. And I'm not gonna say he just kind of gave up, but I think at that point, he just kind of understood that he messed up. And it was the wrong response, so there's no justification for it. There is no good answer. The only analogy that I can kind of give you that I think might, resonate with you is, I know that you're a college football fan and, you have your team and one day your team comes out and they're a good team, they're a great team, and they lose a game they shouldn't lose, and they play terrible, and they can't do anything right. But you don't give up on them, and the next week they come out and they beat the Aggies or somebody like that. And Ricardo's, the Aggies. Ricardo's kind of like that. He's a good guy. And talking to him, he is. I've seen pictures of his children. He's a very good father. He works and supports them. He didn't go anywhere. He just didn't call and get caught back up. But I told him, had you done that, we wouldn't even be in this boat, most likely. What I'm asking, and it's a big ask, is the court can put him on a regular probation. I do believe and know that he can do the things you ask him to do. And jail, it's an eye opener, but it's a bit of a cop out because you're right. In jail, hell, I'll do anything or say anything because I don't want to be in jail. I don't want to go to prison. Do I believe that he will do the things you want him to do? Absolutely. I do. I've talked to all these people behind me. He's got that. He's got great support. And I told them, you got to get on him. If he's, you got to stay on him. We should never have gotten this far, but we did. And so the prison, of course, it'll be there waiting for him. And my ask is that you take him off deferred, put him on regular, and let him do all the things that he still needs to do and will do. I can't explain his actions. I know part of the beginning, but the rest of it, he just screwed up. There's no excuse. He screwed it up and he knows it. But he wants to make it right, and I believe he can. And so I'm hoping the court kind of sees that in him and allows him to do that.
All right. So I want you to know that I listened to everything that everyone said. I've internalized everything. However, I just don't think you would be a good candidate for probation because nobody's seen you since 2021.
Please, Your Honor.
I'm sorry. So I'm going to revoke, find you guilty. There's an affirmative finding of family violence. I'll give you credit for any time served. Does anyone want to speak to time? State is requesting 3 years.
I mean, obviously, Judge, I'd ask the court to recommend the minimum term if possible. He does not have that much time in. He does have 4 dependent children. They're going to be suffering alongside him too. I don't believe he has, I don't recall his history prior to this, but I don't think I don't think there was anything else there. So the court could recommend a minimum term sentence, Judge. That's what.
Your Honor, I'll do anything to put on probation. I'll finish it, Your Honor. If it's to add a year or 2 to my probation, I'll finish it, Your Honor. I will. I'll do whatever it takes just to not be in there anymore. I'll finish it, Your Honor.
All right. This is what the court is going to do. The court is going to, as previously stated, revoke, find you guilty. There's an affirmative finding of family violence. The court will give you credit for any time served. The court will sentence you to 3 years in the prison and the court will retain jurisdiction. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a right to appeal. It's a limited right to appeal as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right. Yes or no?
Yes.
All right, we can go off the record. So here's the thing. When you go to prison, you better show me something. Your attorney will explain that to you. Do you understand? All right, and what is this on the side?
I got that since I was younger.
All right, make sure you get a doctor to check that out, okay? And your attorney will talk to you about everything that I've said and what it means. All right, thank you.
Thank you, Judge.
You're welcome.
All righty, let's go back to Judge McNally.
Controlled substance back on January 9 of 24. A violation was scheduled for April 11. He did not favor us with his presence. He then was here July 10th. He's got, and I want Elizabeth in here, please, Beth. He's got a 7-count violation. How's he going to proceed? Hey, can you mute the jail, please? Thanks.
My understanding, Judge, you'd already pled, we're just here for sentencing.
Well, Judge Kirsten wrote not guilty.
I have it down on the docket as a sentencing. I did ask.
Well, let's take the plea anyway, just to be safe, because Judge Kirsten wrote down, check the box, not guilty. And either he made a mistake, which I think is probably not likely. Yeah, he said arraignment for probation violation, not guilty, set hearing. So he has 7 counts. Is he going to be pleading guilty to all 7 counts?
Yes.
Is that what you want to do, sir? Yeah. If you plead guilty here, your 7411 status could be revoked, conviction entered, you'd be subject to a 1-year jail term. Do you understand that? Yeah. You didn't sign an advice of rights.
He does have one actually, Judge.
Can you hand it up, please? Did you read that and understand that?
Sir, I did everywhere.
If you plead guilty, you're giving up all those rights, and we're not going to have a hearing of any kind. You understand that?
Yep.
All right, as to count 1, to the charge, you failed to attend your scheduled probation visit on April 1 of 24. How do you plead?
Yep.
Count 2, that you failed to attend the court work program on 7 days on the court work program. How do you plead?
Yep.
Count 3, that you failed to pay fines and costs as ordered. How do you plead?
Yep.
Count 4, that you failed to submit the weekly testing as ordered. How do you plead?
Yep.
Count 5, you failed to provide proof of employment. How do you plead?
Yep.
Count 6, that you failed to provide verification of attend your scheduled probation visit on April 1st to 24.
Yep.
Did you fail to schedule and attend 7 days on the court work program?
Yes.
Did you fail to pay fines and costs as ordered?
Yes.
Fail to submit the weekly testing as ordered?
Yes.
Did you fail to provide verification of attending 12-step meetings twice per week after inpatient treatment?
Yes.
Did you fail to provide verification of attending and completing intensive outpatient treatment?
Yes.
Anybody in the world force you to plead guilty?
No.
Anybody promise you anything?
No.
Please accept it, all 7 counts. I find them to be made voluntarily and understandingly. Ms. Wilds, your name?
Elizabeth Wilds,
Did he go inpatient?
Your Honor, Mr. Schmidt never showed for his instructional. That show cause is all encompassing, where he did not show for his instructional. So on April 1st, he was scheduled to report into probation after his release from Oakdale, to get instructed on his terms and conditions of probation.
Do you have the screening report?
I do, Your Honor.
You didn't go inpatient either.
Yes, I did.
Where's your proof? Let's see your proof.
I didn't bring that, I didn't.
Why not?
Realize I was supposed to. I had turned myself in the warrant last time. They said I was just coming here to, they didn't tell me they.
Slow down. Slow down.
They didn't tell me.
Slow down. Did you successfully complete inpatient treatment?
Yes, at Oakdale I did. I
Yeah,
received a certificate. I had it at home.
And then what?
He became homeless.
Hang on. Go ahead.
In April of 2024, Mr. Schmidt became homeless and he did not have stable residence until December of 2024. And this happened shortly after he left rehab. Judge, at the time, Mr. Schmidt did have 2 children, he does have 2 children that were with him, a 15-year-old and an 18-year-old. So he was in the process of trying to find somewhere to house his family, Judge, as well as he was out of his job and he had no money. Ultimately,
Well, because he was spending it all on opiates,
correct, Judge.
right? I mean, he's fentanyl. He's got it all going on here.
Understood.
Fentanyl, coke, crack, hallucinogens, and I mean,
But he successfully did complete the rehab program, Judge, and at the time he was looking for employment. They ultimately ended up moving in with his wife's parents, his in-laws.
when?
In December of
So
2020.
for 8 months, 9 months, he went home, he was homeless with his kids and his wife?
The kids ended up moving in there first before me, and then I moved in December.
The kids and the wife moved in there, you mean?
Yeah. Shortly after.
When did they move in?
Instantly,
Well, then why didn't you move in?
because they didn't want me to, until I showed some progress.
Well, that's good.
Ultimately, Judge, he does have employment now. He's been working, and he will be receiving his first paycheck tomorrow. So he is able to he is able to pay up his balance. He is able to afford to pay for the court work program, Judge, any fees that are associated with that. And he will be going to probation, Judge, to make any other arrangements.
Let me see the police report, please.
Yes, Your Honor.
I mean, you had all right, crack pipes at Trenton High School falling out of your penis. Did you do anything after you went inpatient?
What do you mean?
Did you do anything? Did you get any kind of treatment? Did you go to AA? Do we have proof that you did anything since you've been out of inpatient treatment?
No, I've went to some NA meetings,
Don't-
but, no, I've been to some, I'm not saying. I went
Okay,
every
let's
day.
see your proof of that.
I don't have proof of that. I went when I was living in the 3 courthouse.
How long was he inpatient, Mr. Gates?
18 days or before I got the certificate, 19 days.
Any thoughts?
I don't have a lot of thoughts, Your Honor. As far as Mr. Schmidt's concerned, I mean, he had plenty of opportunity to communicate. An 18-day inpatient program is very small.
I ordered 3 months. I said 3 months.
Yeah, I mean, I will, and, you know, we communicated with him by email, by mail. So if he was homeless from the address on Windsor, we did try to communicate with him by email as well. And at this point, you know, this February will be his 2-year marker at this point. February of 24, I think, is when he was placed on probation.
Judge, if I may, Mr. Schmidt had no prior violations before these items. Obviously, he was going through some issues. Now that he says he's cleared up all his other issues and can focus on getting his life together, Judge, he's more than willing and able to comply with the court's order. We asked the court to give him an opportunity to do so.
At least I can prove myself to you guys. If I mess up, you can go ahead and throw the book at me. But let me show you that I can.
You did nothing.
I realized I did nothing. I was in a really bad area, but now I'm good. I got my head on straight. Let me prove to you that I can do this, please.
Warrant was issued for your arrest 5 days before I sentenced you. I don't know if I was aware of it or not, for assault or assault and battery, and as far as I can tell, you haven't taken care of that yet, have you?
Well, when I looked at my name.
True or false?
The only thing when I looked up for my name, this is the only warrant I had. If I saw a second one, I would try to deal with that too. I'm trying to.
Amy, can you run his lien again?
Sure.
So we're gonna find out if you were lying to me or not. Because I show a warrant from November of 23 out of Dearborn Heights and another one from February of 24 out of Dearborn Heights.
If it wasn't online. This one was. That's how I found out that I had this one.
What'd you think? We threw the file in the garbage?
No, I didn't.
Well, come on. You got a big problem here, young man. I understand addictions. I understand drug problems. I get it. That's why we have a sobriety court and have had one. But you didn't get yourself any help. You went in for 18 days. I wrote down twice a week after inpatient completed. And I said, you're to remain inpatient at Oakdale until released, having successfully completed inpatient, then to attend IOP and complete it. Did you walk out of there?
Got a ride, Uber to the 3 courthouse from Oakdale.
How long were you in the 3 courthouse?
2 weeks until that was the free stay, and then I had no one to keep paying.
2 weeks, you said? I'm sorry, did I understand you correctly? 2 weeks?
Sorry, what?
Did you say 2 weeks you were in the 3 quarters house?
Yep.
Where was that at?
Inkster and Cherry Hill.
What's the name of it?
I don't know, but it's the guy that owns Bush something, a landscaping company in Westland. It's right off of Ann Arbor Trail.
That narrows it down. You don't think I know who owns Bush Landscaping?
I just know he has a bunch of houses. I didn't know if it was in the court system or, you know, whatever.
Judge, Mr. Schmidt says if he tests today, he'll come up clean. So he's made some progress, Judge, I would argue. He did walk in on his own, so that shows some initiative for him to take care of his outstanding issues.
I know, but we do not have he doesn't have enough time here, in my view. I gave him 20 months. There's only 7 months left while I can have him on probation.
I think he'll make a dedicated effort to finish everything.
I'll do anything he asks me to do. I'm ready to keep on going.
June 11th, he walked in on warrant, but left before meeting with attorney or seeing judge.
The ride that I had to go.
What time did you walk in?
I think 10 o'clock, and no, 9:30, and we left at like 10:45.
Did you talk to a lawyer?
I didn't get to see anybody. I just sat there waiting. And then finally my ride was like, I gotta go. I was like, all right, let's go. I came back as soon as I could. I was working under the table until I got a car. Got a car, I'm driving out here. Now I gotta leave the job after that warrant got dropped. I'm trying to get everything dealt with. Trying to get out of the place I'm staying at, get my own place, bring my family. I can't do that in the jail cell.
Point 7411 status is revoked, conviction entered. And I will sentence him right now. All right. All right, anything you want to say in addition?
I have, do you have?
Case? Can I have another first page of the register? For misdemeanor. Is there anything else that anybody'd like to say before I sentence him? I mean, yeah, just the first page. Misdemeanor. Mr. Gay, anything else?
I have nothing else, Judge. I would ask the court to consider, although the 7411 was revoked, Judge, I would ask the court to continue to keep Mr. Schmidt on probation. I believe that he is sincere when he says that he is dedicated to resolving these issues and carrying and fulfilling the conditions the court requests him to do. I don't know that at this point, Judge, jail would do anything more than just hinder his progress, because he does have a job. He's only been there 2 weeks. It's steady employment, it's good money. He's in the process of getting some money together so he can move into an apartment with his family. So I think I would ask the court to consider maybe additional probation for the remainder of the time. And just that jail time would not serve, would not do anything to help his efforts.
So he spent 3 days in jail initially. Anything else? Ms. Wilds, do you have anything else? I know I asked you. There's nothing for you really to say here.
Yeah, I mean, I spoke with Mr. Schmidt on Zoom the date of sentencing. He was well aware of, his obligations after treatment. Like I said, we reached out to him twice by mail, once by email. And I haven't heard from him from the time that I spoke with him on Zoom. So he's fully absconded. I know counsel said no prior violations, but of course there's no prior violations when he absconds.
Yeah. This is a new sentence. I just want everybody to be aware. So it's $100 fines, $500 costs, $600. I'm going to give you credit for 21 days served. I'm going to take you at your word on the inpatient. I'm going to order 51 days credit, 21 served, 30. You'll serve 314 more days if fines and costs are not paid. You can start to pay. I'm going to give you some time to get your feet on the ground. So 50 a week you start paying beginning October the 10th, 50 per week beginning October the 10th. So you're going to serve 30 days. And again, if you don't have the money to pay 50 per week beginning on October 10th, or you have that one, have the next one, don't have one, you call the court, we'll go on Zoom, or you can walk in here on or before the due date at 8:30, and I'll be glad to give you an extension. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that?
Yeah.
I wish you would have taken advantage of this. I really do. Good luck. People against Daniel Burton.
Okay, friends, it's a couple of minutes early, but this is a logical place to end the show today. This is our kitten friends. They are resting, but Ellie sees them up on the big screen there, and she's very interested. So maybe I'll leave them up and let her watch for a little bit until I get ready to go trim her claws, because she just drew blood from me. I hope you all had fun today. I know I did. I think we had some pretty good court all in all. We'll be back this evening, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar. Now, I know the first couple of times had hiccups. However, Bailey and Ashley and Michael will attest we have fixed those hiccups. We will be there tonight. It will work, and we will have a great discussion. So be sure to join us right back here on this channel. And other than that, we'll be back tomorrow morning, 10 a.m. Eastern, 7 a.m. Pacific, half an hour early for channel members. Look forward to seeing you all this evening and tomorrow. In the meantime, go have yourselves a great Thursday. Take care, and God bless.